So our case is distinguishable from those cases. It's very important to emphasize that. And I was submitting that even when the court comes to looking at constitutional damages and quantifying the constitutional damages, the periods of the interference is important because it relates to the extent of the harm that was caused and the extent to which that harm must be assuaged by constitutional damages. So when we say that we want to show that during the currency of my client's tenure, there was no interference, is important even to the constitutional damages question. Whether one talks about whether it flows from that period's interference or the extent of the damages that they might be entitled to, it all is relevant. So, and unlike most of these witnesses who come to court, like Malene Trent sent us a copy of a judgment, we've looked at it briefly, but we'll deal with it in reply, in which Mr. Koko sought to intervene in a review application. The court even remarked that whatever he wants to say is not to assist the court. He's not coming to assist the court because what he wants to present is irrelevant to the issue in dispute. In fact, at that point when he came, the judgment had already been rendered without discussing his conduct at all. Here, we want to assist the court precisely by presenting relevant evidence to dispute the allegations on which the application is based. So we will be submitting, my Lord, that we are directly in the Wayne and Libya exception. And we don't understand the argument to be that Wayne has been overturned. The Constitutional Court would have said so in Libya. It doesn't say so. The subsequent judgments in Zuma and the likes are dealing with a different set of circumstances. And so that's not an override of Wayne in this respect. Can I then go to the relief that the applicants seek and just take the court to what that relief, the relief, my Lord, will find is at 01-4 of the papers. That is in its unamended form, and it is to be found in the amended relief is 006-4. The amendment, perhaps, if my Lord is able to have both open, then one will see the impact of the amendment. But first, at 001-5 is the first prayer. There, the court will see that what they want declared is they ask for an order declaring the conduct. It's important to bear in mind that we are dealing with conduct of the first to sixth respondents. That includes the NDPP, the National Police Commissioner, and the NDPP, and Minister of Police, in unlawfully refraining and or obstructing the investigation and or prosecution of apartheid-era cases referred to by the Truth and Reconciliation Commission to the NPA, or to otherwise unlawfully abandon or undermine such cases to be a violation of rights. So that conduct is a violation of rights. The conduct is inconsistent with the constitutional values in Section 1A and the rule of law in Section 1C. It is inconsistent with principles, values, and obligations arising from the Promotion of National Unity and Reconciliation Act. It is in breach of the duties and obligations contained in the Constitution, the NPA Act, and the like, and not to interfere with legal duties of prosecutors and law enforcement officers, and is inconsistent with South Africa's international law obligations in terms of sections 231 to 233. And then, as a consequence of that, they want the payment of constitutional damages by the first respondent for purposes of affirming constitutional values, vindicating the rights of the applicants and families, and deterring future interference in the following amounts, so that's all quantified. And that's all linked in the amended notice of motion to the period for that interference. The court will see at 006-5, the amendment is to conduct until and including 2017, and that's all. So excluding the administration post-2017. Now, my Lord,
what happened in 2017? It's not germane here, but
I think 2017, the term of office of President Zuma ended. I think he probably ended in February 2018, and the current president took over.
Yes.
So 2017 was the ANC conference electing a new president, and then subsequent to that.
Yes, but my question goes to in 2017. All of a sudden, things started happening, or
it's unclear to us. It's unclear to us whether they say that prosecution started, because you will see there are still debates about whether you're going to have an inquiry, whether you're going to have a commission of inquiry with this current administration.
Well,
So
there is a commission of inquiry
there
which has
is.
now been established.
Yes, the point I'm making is it doesn't seem that magically post-2017 things just started happening, because there were still engagements between the applicants with the current administration, but they're not impugned, the current administration. That's the only point I can make about that. But coming to the relief, so in relation to former President Mbeki, his tenure was 1999 to 2008. So it falls within the time frame they indicated, and the court will find that at page 004-14 at paragraph 1, that's in the founding affidavit. It's 1999 to 2008, and Minister Mabandla's term coincides with that, not fully, it's 2004 to 2008. But when one goes back to the relief in paragraph 1, it's clear that what's aimed at is conduct. And the cited administration is the government of the Republic, the President, the Minister of Justice, and the Minister of Police. Those are the current administration. But of course, those are cited because, as Malot said, they succeed to the previous obligations. But the cause of action doesn't rely on their conduct. The cause of action doesn't rely on the conduct of the present administration. When they refer to conduct in the notice of motion, they're talking about conduct of the Mbeki administration and subsequent administrations until 2017. And as I've already indicated, my Lord, it's really to state the obvious that conduct is committed by a person. That's why the founding affidavit names the members of the administrations who committed this conduct. It constitutes acts, they name the acts in detail, and they are the consequences that they violate the Constitution. They make very clear that they link the conduct with the violations and say in the circumstances an order must be issued. So we don't understand the argument they make that the court determining the main application, and here we respectfully remind the court that it is not this court, because this court is merely determining whether we've made out a case for intervention. So this court, our first submission is that court, even if it were this court, would have to grapple with the allegations of fact which make out the conduct, which say when that conduct took place, what consequence that conduct had, whether indeed it interfered with prosecutions and caused abandonment of prosecutions and therefore breaches the Constitution and the related acts, in order to issue the order, the declarator. One doesn't issue the declarator in vacuum. The submission from the applicants, but we are mistaken. All the court will have to determine is whether there was a plan, a scheme, etc., to interfere with prosecutions. But a
there's
plan
no one
is
in the current administration who can attest to that.
no one.
The conduct complained of is the conduct of other parties,
Yes,
historical parties.
absolutely.
The current president doesn't know.
Yes, and no one will be, other than paying damages, constitutional damages, no one in that administration will be affected by an order. their legal rights affected by an order. It's our clients. When they say the conduct of President Mbeki interfered, and this court concludes that he breached the Constitution, and because his conduct interfered with prosecutions, when this court makes that order, it doesn't matter what a commission of inquiry says in the future on that point. And he can't reverse that on appeal because he'll be in the position of a witness. They'll say, well, we are precisely in the position where you were when and the SCA told you you can't intervene in those circumstances. So he's between literally yes, they're really between a rock and a hard place. They talk about ulterior motive because here they're protecting the ANC 37 against prosecution. That's why they hashed the scheme. The current administration can't speak to that. So this court can't determine, based on a full conspectus of facts, on whether the case is well made out, unless my clients speak. And so with respect, we submit...
Well, the effect of, and Mr. Chaskelson will, I'm sure, deal with this. The effect, your client says, is that if he's not given an opportunity to put the facts, or to set the facts straight, as he says, from a historical perspective, he'll be branded with the mark of Cain as the president who undermined a very important part of what needed to be done for our country to move forward.
Yes.
It would be really quite an indictment, and not in a direct way, in terms of a direct finding, but by implication.
Yes.
By virtue of the fact of the payment of the damages.
Yes.
So the finding you need the finding of wrongdoing for the payment of damages, however those damages are cost, whether it's delictual damages or constitutional damages, but there still needs to be conduct, breaches of rights and behavior, which is a requirement for those damages to be paid. And so you say that by implication, if damages are paid and he's not, as the purported wrongdoer, given an opportunity to set the record straight and give his version, it's something from which he can never recover, because a finding will be made against him, and that will be that.
Yes, the finding will be made in the course of judgment, because the court must determine that there was conduct which breached the Constitution.
Yes, well, there'd have to be a positive finding,
yes.
Or not positive. There'd have to be a finding, either that he acted positively or by omission didn't do what he had to do. Either way,
yes.
In order to ensure that the recommendations for prosecution proceeded and so on.
Yes. So
there's very specific things referred to in the papers regarding discussions with individuals and so on.
Yes.
Is there anybody else that can answer to that, other than the direct evidence of the parties to those discussions?
Yes. They say he met with generals to reach agreement to avoid prosecuting the generals in exchange for no prosecution of the ANC 37.
There's the discussion with Mr. Pikoli as well.
The discussions with Mr. Pikoli.
And what was said by Mr. Pikoli when he was given the letter to stand down.
Yes.
All of that's directly relevant.
Relevant.
But relevant insofar as, and this is Mr. Chaskelson's case, as far as your client's good name and reputation is concerned.
No.
He says it's enough that as a result of the historical timeline, nothing happened, that based on what they've put forward in the founding papers, an inference can be drawn of wrongdoing. They go further than just inference, but that's the starting point. And that you should just be satisfied to accept it as it is, so that they can take the next step to claim damages.
Well, that's not enough, because the wrongdoing will be by particular individuals, but by him. It's not, you don't infer wrongdoing simply from a collection of facts. It's facts disclosing conduct that is in breach of the Constitution. And And the applicants are not intervening merely to set the facts straight. It's to undermine the allegations on which the application is based, as far as it concerns the applicants, to dispute those facts. And so to undermine the relief to the extent that it hangs on their conduct. It depends on their conduct.
What does one make of the fact that I understand the relief that's claimed by way of for the Commission of Inquiry and so on was, I think, correctly sought through motion proceedings, but that damages are claimed in this way? Does that have any significance? That this isn't a case where a witness can be called, whether he's a party or not, to have his version tested. This is all on paper.
It's all
and if you're not given the opportunity to put your version on paper, your version doesn't see the light of day.
It never sees the light of day.
I mean, the applicants have chosen that course of action. They've chosen motion proceedings.
Yes.
I'm going to hear from Mr. Chaskelson on this particular aspect as well.
They have chosen that, and the facts on which they want relief are facts which directly implicate my client, and the court must make positive findings based on those facts that there was a breach of constitutional obligations by his administration and himself and Ms. Mabandla to warrant the grant of the relief. So that was in relation to the notice of motion. And in respect of conduct, it's important just to remind the court of the chapter and verse of conduct set out in the founding affidavit, which they say it took place during the tenure of former President Mbeki and Minister Mabandla, which is the basis of the relief they seek. You will find, my Lord, from 001-65, there are discussions relevant to the conduct prior to that, but perhaps what I can, from paragraph 0, page 001-65, they set out the political interference, the facts regarding the political interference. And they say in 122, in fact, the TRC cases were deliberately suppressed following a plan or arrangement hatched at the highest levels of government and across multiple departments. This is the real explanation for the delay. The interference stands as a deep betrayal of those who laid down their lives for freedom in South Africa, including my father and other fallen comrades. Yes. And then,
can there be any quibble with the latter part of that statement? If you change the word interference and you replace that with the delay and lack of action.
Yes, there will probably be.
That can't be. I think we must accept as a fact that this process 30 years later still hasn't reached its conclusion. Quite. Is an indictment on all of us. But whether it's in consequence of a deliberate action to subvert progress is really what this case is about.
That's right.
The pointed case is that was something deliberate. It could have been as a result of neglect, it could have been as a result of other things.
Yes.
But that's not the case.
That's yes. So if the complaint was delays, but no allegation that particular administration, particular individuals hatched a plan to deliberately interfere with TRC prosecutions, my clients would probably not be trying to intervene here.
Well, there would be no claim for damages.
There
would be no wrongdoers as such.
Yes, the wrongdoer is.
I'm not sure although perhaps the general neglect may found a claim for constitutional damages, but that would be something different. That's not the case here.
Yes. And then you will find from paragraphs 124, 125, 126, and subparagraphs 127, 128, that they deal with the role of the former President Mbeki. You'll see they say he opened the door to political interference. That's the heading at 001-66. And they refer to his statement to the National House of Parliament. I'll not read the statement. That's the statement they say laid the groundwork for political interference. And 125 carries on. And then 126, it appears that the seeds of the political interference were laid in the deliberations that led to the strategies that are reflected in Mbeki's speech. While Mbeki appeared to disavow another amnesty because of its constitutional implications, he nonetheless made it clear that certain arrangements would be made. And they carry on regarding his conduct. And then they carry on with the closing down of TRC cases under the heading following Mbeki's speech. So those wielding in power and influence wasted little time in closing down the TRC cases. Within a few weeks of the speech, attempts by the PSCLU prosecutors to commence investigations were blocked when they were refused investigative support by the DSO and SAPS. And the narration continues. Paragraphs 129 to 237. It's all a description of the schemes that were hatched to stop the investigations. And then you will see in at 173, they say, eventually it emerged that between 2003 and 2004, an effective moratorium was placed on the investigation and prosecution of TRC cases. The prosecutors said their hands were tied as they were waiting for a new policy to deal with the so-called political cases. And they discussed the moratorium until page 001-95, where they now deal with direct intervention to stop prosecutions. And you will see at paragraph 183, they say, according to an interview conducted by the author Ole Bubenza with Wagenaar in Pretoria on 8 May 2006, when Wagenaar was advised that the arrests were going to be effected, he immediately intervened politically and put great pressure on the government to stop the prosecutions. Wagenaar claimed that authorization to suspend the arrests came from President Mbeki in an extraordinary swift move. And then they discussed later discussed the prosecution of those who were involved in the poisoning of Reverend Chikani, you recall in the affidavit. And you'll see at 220, paragraph 220, that's 001-109, they say the decision to prosecute those implicated in the attempted murder of Chikani was the tipping point which saw the complete unraveling of the attempts by the NPA to hold apartheid-era perpetrators accountable for their crimes. And then immediately below that, they say the politicians intervene. And there they discuss the interventions by various politicians in the Mbeki administration. See over the page. And at 225, they say, they refer to meetings which were attended by members of the Mbeki administration with Pikoli and others in the NPA. And they say at 225, at this meeting it became clear that there was a fear that cases like the Chikane matter would open the door to prosecutions of ANC members. And they refer to the what they quote from Pikoli's affidavit, and then makes allegations at 226 to 227. This meeting pointed to what was probably the overriding concern of government, namely that pursuing a TRC case like the Chikane matter would place pressure on the NPA to pursue cases against ANC members. And they then refer to meetings at the presidency's office, and that during President Mbeki's term. And 001-114 at 236, they say the penny finally dropped with Pikoli towards the end of 2006. 237, it was becoming apparent that the central concern of government leaders was that the pursuit of the TRC cases could precipitate cases against ANC members, and for that reason all cases had to be stopped, even if it meant denying justice to the families of Nokuthula Simelane, the Creddock Four, and others. And we don't quibble with the fact that they require justice to be done. But the point here is simply that a case must determine who interfered, if there was interference on a proper case. And my clients have a right to dispute the allegations that are made here and the entitlement to relief in respect of their conduct. And you'll see in these paragraphs regarding Mr. Pikoli, that's when the allegations are made directly against Ms. Mabandla also. You'll see at paragraph 242 that on 6 February 2007, Pikoli had a meeting with Minister Mabandla. During this meeting, it appeared that she had gained the impression that Pikoli had previously agreed not to pursue the TRC cases. And then at Mabandla addressed a letter to Pikoli titled TRC Matters, where she said that TRC prosecutions were going ahead, caught her by surprise. And 245, according to Pikoli, he was at a loss to explain how the minister reached such a conclusion. Her letter disclosed an assumption that the TRC matters would not be prosecuted. Pikoli's affidavit, and then they quote from Pikoli's affidavit in the Nkadibe matter. Then at 247, in this memorandum, he sent a memorandum to Minister Mabandla, and they say 247, in this memorandum, Pikoli bluntly concluded that there had been improper interference with the work of the NPA in relation to the TRC cases, and that he had been obstructed from taking them forward. And then you will see over the page that he says he never received any response from the minister. And he says at 248, they quote from Pikoli saying there was interference. And 249, remarkably, Pikoli never received any response from Minister Mabandla to his memorandum, not even the barest denial that her department was complicit in the improper interference in the work of the NPA. Given the alarming matters he raised, and given that the law criminalizes obstruction of the work of the prosecuting authority, Pikoli indicated in his affidavit in Kadiming that he was shocked he did not get an immediate response from the minister. This suggested to Pikoli that the minister preferred for the deadlock between the NPA and DOJ, SAPS and NIA to remain in place. And then at 001-120, 251, the blunt statement by Pikoli that the prosecution of the TRC cases was a politically sensitive issue, and whenever there was an attempt to charge members of the former police services, there was political intervention, and effectively the NPA was being held to ransom by the former generals, should have set alarm bells ringing. And he was expressing his frustration with the intervention by politicians. And then you will see that they say at 259.
Does Mr. Pikoli ever say your clients instructed him not to prosecute?
Well, they allege that. Well, they don't
in these affidavits.
They don't allege that he instructed him not to prosecute.
Yes.
But what they do say, the applicants, is that Pikoli's consents proved to be prescient, that this was the politicians, the administration didn't want the prosecutions to take place, because they say at 259, within a few weeks he was removed from office, and the Chikani case was the last indictment issued in the TRC-related case for some 10 years. The TRC cases would remain suppressed until the family of Nokuthula Simelane went to court in 2015. So what they then are alleging in the following paragraphs about knives are out for Pikoli is the president removed him from office, suspended him in order to stop him from prosecuting TRC cases. They say knives are out for Pikoli. Shortly after the Chikani plea and sentence agreement had been confirmed in court, a newspaper article appeared in the Rapport newspaper of 19 August 2007, in which it was claimed that the NPA was preparing to prosecute ANC leaders. According to Pikoli, the claim was made on the basis of a note that Ackerman had prepared more than 4 years previously when he first looked at the knives, the universe of possible cases. That note was forged to suggest it was made recently and that Ackerman was targeting ANC leaders. Then 261, they say the Minister of Justice, Menzies Melani, had approached Pikoli and raised concerns about Ackerman's handling of TRC cases. After 262, Pikoli was summoned to a meeting of the Subcommittee of the Justice, Crime Prevention and Security Cabinet Committee on Post-TRC Matters, which was held on 23 August 2007. This meeting was attended by several cabinet ministers, directors generals, and Silebi. Cabinet ministers included the Minister for National Intelligence Services, Ronnie Castros, Minister Mabandla, and Minister Skweyiya, amongst others. The fact that there was a special cabinet committee on the post-TRC case speaks volumes. The existence of a high-level committee devoted to a particular class of criminal cases pointed the importance of these cases to cabinet, and that the case had become the subject of political intervention. Pikoli's account of this meeting in his Nkadiming 2 affidavit is that those at the meeting immediately demanded answers from him about TRC prosecutions, the gloves were off, and that he was declaring war on him. He says Silebi said that. Then he says 264.3, Minister Mabandla told Pikoli to stop this investigation, to which Pikoli responded that the investigation will proceed. Then 265, on 8 August 2007, Pikoli received a fax letter from the minister, which they annexed. She referred to the meeting of 23 August 2007 and noted that SAPS held a different view in respect of the forgery. She complained that she had not been advised of the decision to investigate and wanted to know the basis thereof. He responded. Then Pikoli confirmed that there was no investigation against the 37 ANC leaders. He requested a meeting, and they say over the page at 270, the minister did not respond to Pikoli's request, and the meetings never took place. On 23 September 2007, Pikoli was suspended from office by President Mbeki. Shortly after his suspension, he learned that Ackerman had been relieved of his duties in relation to the TRC cases. According to Ackerman, he was summoned to Advocate Mukoteli Mche's office, that was the acting NDPP appointed after the suspension of Mr. Pikoli. Mche advised Ackerman that he was relieved of his duties in relation to the TRC cases with immediate effect. In his affidavit, Ackerman asserted that he had no doubt that Advocate Mche received a political instruction to remove me from the cases. And then they continue.
But that was an inference.
I beg your, it's an inference.
Inference he drew.
Yeah, inference he drew.
He doesn't say that he was told.
Yes.
He just drew an inference there.
But they place reliance on that inference as a basis for the
But there's a number of the statements from which inferences are drawn.
Yes.
Yes.
And then they say the political, they are quoting from an affidavit from Kadimeng, where he says, I have little doubt that my approach to the TRC cases contributed significantly to the decision to suspend me. It is no coincidence that there has not been a single prosecution of any TRC matter since my suspension and the removal of the TRC cases from Advocate Ackerman. The political interference or meddling that I have set out in this affidavit is deeply offensive to the rule of law and any notion of independent prosecutions under the Constitution. It explains why the TRC cases have not been pursued. And then quotes again from Ackerman, who said something similar. And then it says 274, now with Pikoli and Ackerman out of the way, government was in a position to appoint compliant officials to lead the NPA and take charge of the TRC cases. And NDPPs are appointed by the President, Marut. Going forward, the TRC cases were now firmly frozen, and no amount of lobbying and agitating by families and their representatives would move the new leadership of the NPA to act. Then they refer to the Jinala inquiry, which inquired into the suspension of Mr. Pikoli. And you'll see at 278 says, in the Ginwala inquiry, the government made a number of complaints against Pikoli, one of them being that Pikoli's handling of the post-TRC cases did not show sensitivity to the victims and appreciation of the public interest issues that were mandated by the prosecution policy. It was alleged that the NPA concluded plea bargains with Fanny Merve and others without discussing them with the ITT or informing the minister, notwithstanding the political impact on national security. The nub of the matter was, of course, Pikoli's decision to move ahead with the prosecution of Flock and the others in the face of opposition from the political level. That is the Chikani prosecution of those responsible in the Chikani matter. And then they deal with the what Ginwala found and the criticism she leveled against the then Director of Public Prosecutions, Mr. Simelane. And then, as part of the arrangements that they say the President put in place, you'll see at 001-130 are the special dispensations on political pardons. They see that also as at 290, we'll see they say in the last sentence, the use of the pardon power to accommodate perpetrators who had spent the TRC amnesty process was in line with the recommendation of the ATT that were made in 2004. This is, again, in line with what the politicians wanted. And then the subsequent events then deal with the other presidents. You'll see from 296, they're now dealing with President Motlanthe, and former President Motlanthe, and over the page, they deal with former President Zuma. And they discussed that until they discussed the Simelane family legal action, which is at 001-145. And then what follows are matters that followed afterwards, the applications for reopening of inquests and the like, and for prosecutions to take place. And then at page 001-158, they, under the heading, was there a political agreement not to prosecute? Here they're dealing with the, at 370, while the evidence uncovered points to a desire on the part of the government to close down the TRC case in order to protect ANC members from prosecution, there have also been public statements raising the possibility of an agreement or informal agreement between political stakeholders not to prosecute apartheid-era crimes. And what they explain is this agreement would have been made with the generals in order to protect prosecution against the ANC 37 who applied for amnesty but didn't get. And so they suggest, and here they talk about meetings that took place between President and the former President Mbeki, de Klerk, and the generals, facilitated by Jürgen Kohl, which the President addresses in his application for intervention. That too is part of the scheme. A quid pro quo with the generals. We won't prosecute you so that the ANC 37 don't get prosecuted. And then you'll see there's further deliberation on a further immunity at 001-160. Again, here is an allegation of President Mbeki, former President Mbeki, working with the former apartheid government to work out a further blanket immunity to protect apartheid generals against prosecution. And they rely on the book by Mbandla, which they refer to at paragraph 378, detailed secret consultations between the ANC government and representatives of the SANDF and the security police from 1998 until early 2004. The main aim appeared to be to reach agreement on a legislative solution on how to avoid prosecutions in the wake of the TRC. And they discussed that he was meeting with former President de Klerk and these generals. And they say that discussion came to a close at 001-167 at paragraph 304. The talks between the SANDF generals and the government came to a close during 2004 without resolution.
Mr. Mainecha, what is the evidential value of these things from these books?
That's part of the, they're hearsay evidence, but they...
Authors write things for all manner of reasons.
Yes.
I have a difficulty with it, and I'll tell you why. One of my children came to me a few years ago to tell me about something they'd learnt at school to do with a particular march. And they were telling me about the march and all sorts of things. And it was very interesting, except I happened to have been at that march.
Yes.
And I said, but hold on a second. This fact, it didn't happen like that, and no one did this, and they were quite upset with me.
Yes.
To say, but it's written in the book. And are you sure? I said, I remember it clear as day because of something that happened on the day. So, to rely uncritically on what's written by someone else, and one accepts that these things are written in good faith and in belief, and that there's been some research, but it may not be the whole story, as it were. Your case here really as a thread running through all of these things is that if there were any such discussions and so on, your client was present, or would have been present, or would have known, and he is able to shed a light on it if he is a party to the proceedings.
Yes, and dispute them. And,
well, either
and
to dispute or to corroborate, as the case may be.
Yes, corroborate or provide the truth. Because these allegations are relied on to get the declarator that their conduct, as described, relying on books and articles and affidavits and other proceedings, that my clients breached the Constitution, committed criminal offences, and that declarator must issue, because that's the cause of action.
Yes.
That's the cause. If you take all of this out, if you struck all of this out of this affidavit, there's no cause of action.
Yes, it requires through reliance on these various sources,
Yeah.
the making of a finding.
Yes.
In the absence of the person who's best placed to answer to the allegation.
Yes. And the cause of action, the claim that they want against the current administration can't be sustained if you take all of this out, because this is the gut of the case.
Well, the claim against the current administration is leaving aside the Commission of Inquiry and the need for closure.
Yeah.
If one leaves those aspects aside, what's left is money.
Yes, it's money.
And the money part is the part which requires the wrongdoing.
Yes.
Before one gets to that part. Everything else one can get to without having the wrongdoer present.
Yes.
But the money part requires the wrongdoer to be found to be the wrongdoer.
Yes. There must be wrongdoing by the wrongdoer for the money to follow, because the predicate, the predicate for that money claim is the declarator. The predicate for that declarator is my client's conduct. Absent my client's conduct, there is no claim. So when our learned friend says you can find against...
It may be that there's a claim. It may be that there's a claim, but it may be that your client's not the wrongdoer.
Yes. And if
there may be another wrongdoer.
Yes.
Or it may be as a result of something else. One doesn't know what the Commission of Inquiry will uncover.
Yes.
But for purposes of the case as it's presented now,
yes,
my
client is the wrongdoer.
Specifically on your client as the wrongdoer.
Right.
If your client's found to be the wrongdoer for purposes of the damages claim without any more, then one wonders what the purpose of the Commission of Inquiry is when we already know who the wrongdoer is.
Yes.
Because it's there on paper.
Yes.
So why would the President convene a Commission of Inquiry where these things can be ventilated and inquiries can be directed to ascertain the correctness of the position if we already know the outcome?
Yes.
It seems somewhat contradictory.
Yes.
Contradictory course of action.
Yes, as the court says, perhaps for closure, perhaps for the writing of books, which is suggested, or for other similarly placed victims to come before the commission. But as for this cause of action, for this claimants, the case, they say, can be determined on this. You can give them the declarator on this. You can find that there was a wrongdoer and a declarator must issue. And I'll leave the Commission of Inquiry for the moment, just focusing on the case here. So then they at 001-167 they talk about attempts to compile private prosecutions against ANC members and PEC members. Then they again at 399, you see they turn to the book writer. They say, he says, General Jan Geldnes told him at an interview in Pretoria that the former SADF generals were also of the view that the issue of potential criminality of ANC members was a major consideration for the government, and the former military would take the same steps as FEL if they were charged. So again, just drawing that link. And then under the heading, former President Mbeki denies involvement in political interference. So here they refer to an article written in the News 24 by journalist Karen Mon. It says, News 24 on 21 February 2024, journalist Karen Mon pointed to uncontested evidence from various court cases demonstrating that powerful Mbeki administration officials blocked the prosecution of apartheid era cases, and they rely on that. A copy of this article is annexed. Former President Mbeki was approached for comment by this foundation. The Thabo Mbeki Foundation referred inquiries to the current government. But of course the court wants direct evidence to determine this conclusion that they rely on based on a journalist's article.
But isn't that the point? That uncontested evidence.
Yes, that's what they're going to argue before the judge decide in the main application if my client is not admitted. Yes. They're going to say there's uncontested evidence.
You say you want to contest that evidence.
We want to contest it, and my clients have started to put up the skeleton of what they are going to say in their founding affidavit. So they are going to argue, just like the journalist wrote here, uncontested evidence of President Mbeki being the architect of political interference, the executioner of that, if that's the right word. Executioner, I think, is going to do with killing, executing the strategy successfully. It's uncontested. So the declarator must issue. Then they say, however, on 1 March 2024, the TMF released a statement titled Statement by former President Thabo Mbeki on allegations of any NPA interference by the executive, a copy of which is annexed. In his statement, Mbeki strenuously denied any involvement in the suppression of the TRC cases. They quote, "During the years I was in government, we never interfered in the work of the National Prosecuting Authority. The executive never prevented the prosecutors from pursuing the cases referred to the NPA by the Truth and Reconciliation Commission. I insist on this despite a 2021 Supreme Court of Appeal judgment which found, on the strength of uncontested submissions by former National Director of Public Prosecutions, Advocate Vusi Pikoli, that the NPA investigations into the TRC cases were stopped as a result of an executive decision which amounted to interference with the NPA. I repeat, no such interference ever took place. If the investigations Advocate Pikoli referred to were stopped, they were stopped by the NPA and not at the behest of the government, as alleged by the advocate. There is no record of a single instance when the NPA stopped investigating and prosecuting any case on account of the so-called executive interference, at least not during the period 1999 to 2008. Then they continue. Former President Mbeki asked why the NPA succumbed to political pressure and challenged the NPA to produce any illegal instruction from his government stopping the TRC cases. Quote, "There are some questions which the NPA must answer honestly. Who in the executive instructed the NPA not to do its work? Will the NPA publish this instruction, which presumably will be in its archives? Why did the NPA accept and respect that would have patently been an illegal instruction? Instead of propagating falsehoods, the NPA must investigate and prosecute the cases referred to by the TRC." If memory serves, my lord, the case that the former president refers to is maybe the Rodriguez case. But that case was about a permanent stay of prosecution. One can ask, what would the president's business be in that case for intervention? It's different from a case like the present, where the relief is to declare that conduct he committed breached the Constitution. That's a completely different kettle of fish. But they want this court, when it determines the merits of the application, to simply lap up and accept what was the findings that were made in Rodriguez, the comments of the journalist, the comments of the writer, and the like. At 4 integrity by apologizing to victims for not prosecuting the TRC cases. In brackets, conveniently, some people forget that the ANC, they are quoting him again. Conveniently, some people forget that the ANC was the principal architect of the Constitution of the Republic. During the years when I served as Deputy President and President of the Republic, I, together with my colleagues in government, always bore this in mind and acted knowingly that the constitutional prescripts we helped to negotiate were binding on us. There was never any Minister of Justice during those years who was ever authorized to instruct any NDPP to act in any other way or another. No NDPP, including Pikoli, ever approached me to complain that he or she had been instructed by a minister or any other official to violate the independence of the NPA as prescribed by the Constitution. The NPA must demonstrate enough integrity by apologizing for not processing the TRC cases rather than engage in dishonorable behavior of trying to hide behind a fig leaf, which is nothing more than pure fabrication. What do the applicants say? The denials of former President Mbeki are not consistent with the brazen suppression of the TRC cases that occurred during his administration and which has been set out above. The chapter and verse, my lord. It is for an independent commission of inquiry to consider and test the veracity of the denials of former president. But they don't agree to stay their proceedings pending the commission of inquiry. They refuse. They are opposing the stay application. And they're refusing President...
Just on that point.
Yes, my lord.
If one took the view that the commission of inquiry all will be revealed. Your client will testify before the commission. Ms. Mabandla will testify. Many others will testify, and there will be an outcome. that doesn't bind anybody. It only helps your client, at least, if the Commission of Inquiry vindicates your client. And then your client would say, you see, I told you so.
Yes.
But if the Commission of Inquiry doesn't vindicate your client, then we're back where we are now,
Yes.
which is the applicants in the main application seek the declarator and seek damages.
Yes.
Now,
My lord is 100%
it would
correct.
be easy if everyone agreed to postpone everything until after the Commission of Inquiry, because then all will be revealed.
Yes.
But if that's not to be, then one must deal with the case as it is now,
Quite.
and with the papers as we have them now.
Quite. And there are two responses we make to that. Is my lord is absolutely correct. If they say we're proceeding with the application, then for the very reason that they poo-poo what former President Mbeki says in the quoted passages here, that he did not interfere, and the conduct that they attribute to him cannot be found correct by this court. Why do they not want him to come and show that the journalists and the writer are incorrect, and the basis of the relief, as far as the government is concerned, relating to the conduct of his administration, is incorrect, and to that extent that relief can't be granted? Why don't they want that dispute ventilated in an open court in terms of Section 34 of the Constitution? Because there is a dispute. We dispute this allegation, and I'll demonstrate in the founding affidavit in the intervention. But unlike what they say about us, they say, well, in reply, we scurry around to say we have a dispute with these applicants. We say so in the founding affidavit that there is a dispute regarding these allegations, which are the foundation of the application.
Yes, your client's interest, as I understood it from the founding affidavit, it is so, as Mr. Chaskelson says, that there's no specific assertion that we say that no relief should be granted and we oppose the relief. What's opposed is the finding, which is a precursor for the granting of the relief. So the fact that the government may ultimately be ordered to pay money as constitutional damages isn't the issue here. It's whether your client's wrongful conduct is the proximate cause for that payment. It could be that others have done it,
Yes.
committed wrongful acts, which would ultimately yield a successful outcome if the net was cast wider. But in this case, the net it's a small net, and it's caught specifically two persons within it.
Yes.
And their case is predicated upon that. But you don't say, well, we say that there's been no delay, because factually
There has been.
everyone can see there's been a delay.
Yes.
And factually everyone can recognize that these families have been wronged
Yes.
in terms of the consequence of 30 years of inaction and failure to get to grips and bring these matters to a conclusion.
Yes.
There's no dispute with that. It's a question of whether or not your client deliberately played a role to bring about that situation. And
Yes.
he says he didn't.
Yes. And my lord, if we hone closer on the relief in the declarator, which now helpfully sets a time frame. So my client's dispute of the allegations and its impact on the relief will impact the duration of that interference and will affect the period that will be stated in the order. So the court might say a declarator is issued, but doesn't include the period when my client was head of the administration, where the conduct relies on him and his administration. So there is a direct impact on the relief, on the order that is being sought. Directly, there is a direct impact. Yes. And my lord was correct earlier to say, well, we can wait for the Commission of Inquiry, But the Commission of Inquiry's findings and recommendations are just that. They won't be binding on a court, but they may reveal the truth. They might say, well, having seen what came out of the Commission of Inquiry, we limit our relief to certain periods. That's for them. But the court will still have to make the final determination on whether there was a breach by my client's conduct for a period of time. So even if the Commission vindicates, they might disagree with the Commission and still come to court. But at least and it's important. We touched the terms of reference of the Commission. It makes it clear that parties to this litigation are interested parties in the Commission. So if my client is a party to this litigation, he will be party to the Commission. He will testify before the Commission. So it's very important from the discussion, the debate we just had, my Lord, when I go to the law, to bear in mind that we are saying that we are in the weighing category, where the matters that we complain about are issues in this case, and that what we are going to say will affect the outcome and actually the formulation of the relief itself as far as the declarator is concerned, and would have an impact on the extent of the damages, because that by any definition would have to regard to the duration, because the duration is linked to the extent of the harm.
But your client's has no interest in that.
He's not interested
other than the period for which he is said to have been the proximate cause for the harm.
Right.
He says, during my tenure, it didn't happen that way.
Quite.
And it may have happened following on from me, but not while I was the guiding mind for the state.
Yes. And he may be disbelieved by us, but Section 34 entitles him to come to court and have that dispute ventilated in an open and public hearing. Then you'll see, my Lord, at 001-171, they then talk about the period post-political interference, and that relates to the question my Lord asked about, well, what happened afterwards? I think there were some reopening of inquests on applications and the like. But that doesn't concern my client directly. What I need to take my Lord to is, what do they make of all of these allegations that I've just been through? They draw them together under the violations of the law, and you will find that at 001-217. They told you the story, and they say, violations. I'm advised that before I set out the basis for the relief we seek, I must set out the statutory and constitutional provisions that have been violated by the political interference that resulted in the suppression of most of the TRC cases. That interference they've already described. And then they say 528, any agreement or arrangement not to hold to account and punish those who have committed the most heinous of crimes is at direct odds with the most basic feature of South Africa's constitutional order, namely the rule of law. You recall they say the arrangement involved my client with the generals and former President de Klerk in exchange for immunity for the generals. 529, those who impose their will on the NPA and the SAPS not to stop or undermine the TRC case from proceeding, as well as those within those organizations who are acquiesced to these demands, violated multiple constitutional and statutory provisions. These are set out below. So they are directing that to people, you and I, flesh and blood, those who impose their will. Those are my clients. During their time, they violated multiple constitutional and statutory provisions, and they set them all out, the statutory provisions, my Lord, some involving criminal conduct, especially breaches of the NPA Act. And then they say at 001-219, paragraph 530, every constitutional and statutory duty and obligation mentioned above was violated by those who imposed their will on the NPA, and as well as the NPA leadership and its senior staff members involved in the abandoning of the TRC cases. Although the NPA enjoyed exclusive authority to institute criminal proceedings on its own version, it allowed others to impose their will on the authority to stop prosecutions that otherwise would have been pursued. Who are those who impose that will? It is my clients in their administration and those members of that administration. 001-220, 530.2, the government officials and executive members who impose their will or attempted to impose their will on the NPA, and the NPA leadership and its senior staff members involved in the abandoning of the TRC cases violated Section 32(1)AB of the NPA Act. Executive members, we know they've mentioned Minister Mabandla and the letters she wrote, the President and what he did, and the suspending Mr. Pikoli from office because he wanted to pursue TRC cases. 530, the responsible officials also violated their oaths of office in terms of Section 32(2) of the NPA Act and Section 41(1). So they've drawn the allegations to the, and then they say at page 001222, they say 537, the last sentence, the actions of the responsible persons, both within and outside the NPA and SAPS, warrant investigation into whether their conduct violated those provisions. And then they say grounds for declaration and constitutional damages. 538, the suppression of the TRC cases has been almost total in its impact. Virtually all the approximately 300 cases referred to by the TRC to the NPA were blocked from proceeding from around 2003. This suppression lasted for a period of at least 15 years. Its effects are ongoing. The impact on the families of those murdered, their communities, and on the fabric of society is incalculable. Denial of justice. The bulk of the apartheid era cases have come to an end because suspects and witnesses have died, not to mention family members. The primary reason behind this monumental failure of justice has been the political interference which effectively killed off the TRC case. Those behind these machinations knew that this would be the outcome. They must be held to account. Those are my clients. Those, they are not talking about schemes in vacuum. They are talking about those who did these things. And then they carry on, my Lord, if one looks at 001-236, paragraph 566, the conduct of the responsible officials behind the interference has denied us justice within a reasonable time or at all. In so doing, they have exacerbated and prolonged our pain and trauma. We have been denied the possibility of closure of a most painful past. This conduct has breached our rights to human dignity. Those responsible officials include my clients. And they say, and they talk about the various violations, my Lord, it carries on, it's the same thing. And then they draw it completely now to conclusion, 001-240, 577. They say, in the circumstances, I have set out sufficient grounds to warrant the declaration sought in the notice of motion that the interference violated the rule of law as well as our fundamental rights, was in breach of duties and obligations in terms of the Constitution, the NP Act and the SAPS Act, was inconsistent with the principles, values and obligations arising from the TRC process, was inconsistent with South Africa's international law obligations. I submit further that I have demonstrated sufficient grounds for the granting of constitutional damages in the amounts which are set out below. The basis, they tell you, is the political interference by those responsible in the executive and the NPA. They've said so themselves. How now can they say the court doesn't have to decide those issues in order to determine their entitlement to relief? With respect, it is just doesn't bear scrutiny at all. But they are asking this court to make that determination when it is not this court that's deciding the merits. But the court can see, how does a court properly applying its mind to whether the relief is made out, other than to make factual findings on this allegations and determine whether they resulted in interferences and a violation of the law. So those are the facts they say in the founding affidavit, in their founding affidavit. The next topic I need to deal with is the Sharia. I must deal with the law. When I dealt with the law, I didn't take my lord to the Libya judgment, because that's the first judgment on which we rely, which is must be considered together with the Wayne judgment. So my lord will recall that in Libya, this was a witness who had given evidence in a trial in the mesh court where he was not a party. And there were adverse findings, credibility findings made against that witness. And the party to the litigation against whom the judgment was rendered didn't take the judgment on appeal. And he sought to intervene in order to bring an appeal against that judgment. Those are the facts. And you can see they're wholly different from this. They're similar to Zuma, NDPP versus Zuma, where the findings have been made, credibility findings, you're outraged by them, rightly, and you want to have them reversed on appeal. And in those cases, the courts were very clear that such a witness has no standing, because whatever they say has no impact on the order. They're not challenging the order in any form or shape. In fact, what they say may not even determine the outcome. And that's very similar to the case that's been handed up, but it's going to be handed up, involving Mr. Koko. It was a review application. They made findings he didn't like, and the court could demonstrate that if you go back to the judgment, you'll see that nothing was said about your conduct. So the facts you want to put up have no relevance to the determination that must be made. But that is a completely different case from the present one. And here, my lord, the first thing I want to refer the court to in Libya, I can't recall whether that has been uploaded on case lines. We were meant to upload it, but I'll just refer the court. The first is paragraph 17 of that judgment. There the Constitutional Court is dealing with jurisdiction, and my lord knows that the Con Court will take a matter if it raises a constitutional matter or a legal matter of public importance, which is arguable. So they had to ask whether they had jurisdiction first to even hear the appeal. And this is what the court said there is important, because the rights they mentioned there are the rights my clients rely on here. They say at 17, in this case, the applicant seeks access to this court in order to challenge on appeal a finding made against him by the magistrate's court which adversely affects his right to human dignity. This means that this case implicates both the right to human dignity entrenched in Section 10 of the Constitution, as well as the applicant's right to have any dispute that can be resolved by the application of law decided in a fair public hearing before a court, which is entrenched in Section 34 of the Constitution. And that's exactly what we want to do before this court, is to ventilate our right. Then the court turns to the merits, discusses that, and the first point, the first reference I want to refer the court to is paragraph 22 of the judgment. It says, counsel for the applicant sought to argue that there was a link between the order by the magistrate's court and the adverse credibility finding made against the applicant, which gave him a direct and substantial interest in the order. However, the position is simply that even if the applicant were to be allowed to intervene, he has nothing to do with the order that the court made against the second respondent. That order gave him nothing and took nothing from him. That's different. This order is going to find that conduct by my client breached the Constitution and warrants a declarator. My client is a wrongdoer. So the judgment will take something from my client. There will be an order read with the judgment, because the judgment will provide the basis on which the order is given, and that judgment will traverse these facts and make findings that during his administration there was conduct which interfered with TRC prosecutions, of which he was the architect, because that is what they say. He opened the door to political interference and executed that. So just on that, our clients, what the client is bringing, will impact the order, the duration, the period covered in the order, and even whether the order is given to the extent relating to the period of his administration. That's the first part of our case. That gives us direct and substantial interest in the subject matter of the judgment and the order that the judgment will grant. It doesn't matter that the order is not sought against us. That is not the test. The test is not you can only intervene if an order is sought against you. It is whether the order will impact your rights. That's a different question. It's a more substantive question. And then, my Lord, then the Constitutional Court tends to what we say is the second basis on which we rely, and that is the Wayne category. At paragraph 23, it says, the applicant placed some reliance on a statement made by Adelson J. in Wayne, where the court said, where there is an attack on the character of a person who is not a party to the litigation, it is conceivable that there may be a limited right to intervene, provided that it will be essential for the purposes of the judgment that the correctness of such attack be considered and decided as part of the court's reasons for determining the issue between the parties. Then the applicant's counsel also relied on Nahapa, where the court approved the passage from Wayne, and the court's, that passage says the same thing. The allegations you complain about must be essential for the court's determination in its reasons. And then he also referred in paragraph 24 to Wayne. That's still the same point. In that case, in Wayne, because there was no more lease, because the main party wasn't appealing, that was also another basis to deny standing, because whatever he says would be unhelpful to the court, to the judgment. And there are other cases where, in one case, there was a settlement already by the time the disappointed witness wanted to intervene.
Here the dispute is still live.
Very much live. And paragraph 26 refers to the Zuma judgment, where they say, and that's the case involving my client, which our learned friends always hit us with that, and they say we are coming here to do exactly the same thing, when we genuinely are not. We may be misunderstood, but we are not doing the same thing.
But even if you were, each case must be looked at on its own facts and its own merits.
My Lord, I couldn't
And
say that.
this case is distinguishable because of the fact that it's still live.
It's still live.
It's not a completed proceeding with an ex post facto attempt at vindication.
Yes. My learned friends will say, well, that principle applies whether you come and appeal or you come in first instance. If you're just a witness worried about your reputation, but what you say will not impact the determination, you mustn't come in. But we say, what we say will impact the determination. Their answer I'll show, my Lord. Maybe at this point, let me show, my Lord, what their direct answer to this is. Because it's in paragraph 39 of the, and I'll come back to Libya. It's paragraph 39 of the heads of argument. After quoting from Wayne, they quote from Wayne. They don't say Wayne is wrong, was wrongly decided. They apply Wayne and say we are outside Wayne. They said this is the nub of the problem for the intervening applicants. 39.1, the court deciding the declaratory relief and claim for constitutional damages can give judgment on the merits without deciding whether the intervening applicants have personally committed any crimes or transgressions in relation to the TRC cases. I don't know what they envisage. So the court will say, I can ignore all the chapter and verse you've said about the conduct of the Mbeki administration, and I can still find that there was a scheme to interfere with TRC cases. And there is your declarator, which declarator speaks of conduct over a specific period of time. It may not have to say you have committed a crime or a transgression in relation to the TRC cases. Well, it may not say you've committed a crime. We're not saying that's what the court is going to say. But certainly it will say, in relation to the TRC cases, you interfered with prosecution, and your interference breached the Constitution. In consequence, we can declare that this government has breached the Constitution because this government inherits that. But they have to determine what they said. Why did they say it if it doesn't have to be determined? Over so many pages with so many annexures, and journalists speaking all left, right, and center.
Well, if the claim had been formulated on the basis that there was no reference to any individual,
yes,
would a court be able to find damages?
No.
In the absence of any allegations of wrongful conduct on the part of anyone? I mean, there has to be someone responsible for the breach of the right.
Yes. And my lord, that's someone.
There may be a breach of the right which occurs in consequence of circumstance where there's no one person responsible. That's not actionable in the way that they seek to have it actionable here with the payment of money.
Yes.
Those are cases where, well, you've discovered a breach of rights, there's no one that's specifically responsible, but the remedy is to put an end to the breach.
Yes.
It's not the damages contemplated in Section 39.
Yes. My lord, the very prayer that they're pressing this court to give speaks of conduct. Conduct is perpetrated by persons and constitutes of acts over a period of time.
Or omissions.
Or omissions over a period of time. And those persons, my lord, must have the capacity to interfere with prosecutions and must interfere, which is what they say. So you need to have all of that. You can't just say there was a scheme where, by whom, over what period, constituting of what steps. And knowing that they've given the court chapter and verse of that conduct, they can't now suddenly say, well, but the court can reach a conclusion without regard to that. And then they say in 39.2, the court does not have to find that Mr. Mbeki was responsible for the interference or even connected to it to give judgment on the merits of the family's relief. I don't understand how that is possible. Because there's an administration. The administration is an artificial concept.
Made that Mr. Pikoli was removed to stop him from pursuing matters.
Exactly.
I mean,
The
it's clear and unequivocal.
Yes.
The reference to your client going into his study and writing the letter himself.
Absolutely.
It doesn't get more proximate and direct than that.
Absolutely. And the administration acts through officials. So it's an artificial construct. And then they say 39.3, the court need only consider whether there is sufficient evidence in the record before it of a scheme, plan or design to undermine or abandon the TRC cases. Well, it could have been a plan by somebody sitting at some restaurant. That wouldn't be of interest to this court, who is not an occupant of an office in the administration. That would be of no interest. There's sufficient evidence of the scheme, plan or design. The plan, scheme, design is acts by individuals, planned, executed with consequence, which constitute a breach of the Constitution. Then they say in 39.4, this court, Honorable Court, does not have to make findings of individual responsibility. We are not saying the court is going to say, Mbeki, you are responsible. But it's going to say Mbeki's conduct on the invitation breached the Constitution. So when they talk about personal culpability, we're not going to that extent. We're not saying at the end of the day we're going to list individuals in this. The order is so and so is culpable and the like. You're going to say the conduct of who? Read the judgment of these individuals, which were set out in the founding affidavit, uncontested by those implicated, justify the conclusion that there was a breach, which justify a declarator. There is no, this is really the height of form over substance. The substance is there, and these applicants can't now walk away from it on the basis simply that they want to keep the door shut to my clients. If we go back to Libya, my lord, I had referred to the Zuma judgment, that we are not in that situation. What the court then concludes on the facts at paragraph 29, it's, I do not think that the decision in Wayne can assist the applicant in any way. This is more so in the light of the clear position that his interest is really in the adverse credibility finding made against him, and not in the order that the magistrate court made. Furthermore, the fact is that there is no list between the parties anymore, just as there was no list between the parties in Wayne. In this case, the MEC accepted the judgment and order of the magistrate's court and satisfied the judgment. It must also be remembered that there is no appeal against reasons for a judgment, and an appeal lies only against an order. This means that even a party to litigation cannot appeal against any adverse credibility finding that the court may make against him or her, if in the end the order that the court made is the order that he or she wanted, or he or she has opted not to contest the order, a defendant who succeeds in getting a court to dismiss the plaintiff's claim cannot appeal against one or other adverse credibility finding that the court may have made against him or her in respect of one or other issue in the course of his judgment. So the court doesn't say Wayne was wrong. It says Wayne is not satisfied. So we submit that Wayne remains, that category remains good in law, and that category justifies my client's intervention as a second leg for why the intervention should be granted. And you will see that in the reasoning of the court on why one doesn't develop the common law is because the common law already has the Wayne category, which caters for people like my client who are not named, cited directly, against whom no specific relief is sought, but the relief impacts on them, and they are able to dispute the allegations and place matters before the court. What I need to do, my Lord, is to show, my Lord, briefly in the application for intervention, what my client said was the basis for intervention. What they said was why they have a right, and that, my Lord, will find in the founding. Well, the notice of motion is 004-4, and paragraph 1. They ask for intervention as 7th and 8th respondents, and that they will be served with the papers, the full papers, and that they will be directed to file answering affidavits in the time period that this court will permit. And we've tried to explain that might, in the case management meeting, the case is being case managed, the case management meeting will determine the duration.
So do you say, if I'm with you, and you'll discuss this with Mr. Chaskis, and it was foreshadowed in our discussion in chambers, that perhaps the question of the time periods for the filing of papers, if the intervention is granted, be referred for determination at a case management meeting?
Yes, we would submit that is the proper
course. Would that be the appropriate?
Yes.
I'll hear from Mr. Chaskis.
And he's nodding, but I can't hold him to the nod. But
yes, the microphone doesn't pick up the nod.
Doesn't pick up the nod, indeed.
Convert the nod into a yes.
Yes. Okay. Okay.
And my Lord, I've already referred to in the founding affidavit. This starts at 004-13, and you will see there is set out the purpose, which refers to the summarizes the relief, and then discusses the different categories of TRC cases, and then in paragraph 12 sets out the duration of their term, paragraph 12, and paragraph 13 says the relief the applicant seek is underpinned by the main applicant seek is underpinned by allegations of unconstitutional and criminal conduct by me and Ms. Mabandla during our tenure. I've taken the court to that. Given the nature of the direct challenges made against Ms. Mabandla and I, which underpin the relief that the applicants seek, as well as the orders that they seek, Ms. Mabandla and I seek relief to intervene as 7th and 8th. And they rely specifically on the broad standing in the Constitution, because they say that their legal rights will be adversely affected if they are not allowed to intervene. Section 10 and Section 34, I've referred to the Libya judgment that accepted that. And they, Section 38C, they can represent members of the administration and also the public interest, because this is their public interest. Then they say, paragraph 16, in summary, the direct and substantial interest that Ms. Mabandla and I assert arise in the following circumstances. 1. First, the serious allegations of unconstitutional, unlawful, and criminal conduct against Ms. Mabandla and I, as well as the members of the administration of which I was president, are issues between the parties in the litigation. That's the Wayne issue. The court must determine the issues in order to grant the Kalata applicants the relief that they seek. Those allegations are highly defamatory and damaging of our dignity and reputation. The applicants tend to suggest that all we want is to come here to defend ourselves against defamation. Now, we're just saying This met allegations which are serious, which are issues before the court, are also defamatory of our clients. Our character is beyond all price. All these judgments say that. In such circumstances, Ms. Mabandla and I are entitled to intervene to dispute the allegations and serious and damaging allegations made, and to place direct evidence before this court for it to determine the correctness or otherwise of the serious allegations against us on which the applicants rely for their relief. One. Second, and these are independent bases for intervention. 16.2, Ms. Mabandla and I dispute that we or the administration of which I was president interfered with the NPA's prosecution of TRC cases and committed unconstitutional, unlawful and criminal acts as the Kalata applicants allege. We intend to place relevant direct evidence before this court to oppose the allegations on which the Kalata applicants seek relief, and to have legal submissions made on our behalf in that regard. Denying us intervention in such circumstances would conflict with and unjustifiably deny us our right under Section 34 of the Constitution to have this dispute, or disputing these allegations which are the basis of the relief by the applicant, resolved by the application of law decided in a fair public hearing before this court. Once we are denied the right to intervene as respondents and defend ourselves against the serious and damaging allegations, we would not be able in future to relitigate the findings of this court against us. It is unlikely that a court of appeal would allow us the right to intervene to challenge any adverse findings by this court if we are denied the opportunity to defend ourselves as respondents before this court. I am advised that there is authority in the highest court in the land that a witness who was not party to proceedings may not seek to intervene on appeal to challenge adverse findings against him, or where he or she does not challenge the order that the court of first instance has granted. He is aware of the Zuma case and the Libya case. Third, given the allegations of intentional interference with the NPA and the prosecution of TRC cases for alleged personal interest or private organizational interest, the government, represented by the first, second, and fifth respondents, may contend that this court must find that if there was unconstitutional, unlawful, or criminal conduct by Ms. Mbandla and I, in the administration of which I was president, it is conduct that is contrary to public interest, because the government and the public have an interest in protecting the rule of law and ensuring good governance.
Can you just pause there? I was going to ask you, and Mr. Chesterton also, was not a possible solution to the matter that your client deposed to an affidavit on behalf of the government parties to obviate the need and to put their version forward? But you answer it here.
Yes.
Where you say, well, there may not be a confluence of interests, and there may be contradictory positions which get taken subject to what comes out in the wash.
Quite.
So it's not as convenient as simply saying, well, you used to be the president, you were deposed to an affidavit for the period when you were the president, Mr. Zuma, Mr. Mbandla for his period, Mr. Zuma, and now Mr. Ramaphosa for the respective periods, and we'll present a combined narrative of what has happened through the various administrations because of the stick that must be wielded if it's found that there's been a breach of constitutional obligations and oaths by the parties concerned.
Yes, but what can you imagine, and here I'm putting the extreme, if I was here arguing for President Zuma, and you say, well, President Ramaphosa's counsel will represent you, where you will be a witness, and publicly reported 9 wasted years. But the simple point is that, as the court says, there may be no confluence of interest. When somebody is arguing for the current administration, you say we've done nothing wrong. And when they say the previous administration did something wrong, the interests may not be aligned. That's the first. But the second is not an answer to say to a party, you have 2 alternative remedies, you've selected the first one. Well, we are not giving you the first one because you have the second one. No. That we could, all things being equal, if the government was interested in using our evidence, firstly, and that government was opposing, secondly, which it withdrew the opposition and now wants to reinstate. Who knows whether it will reinstate or not?
But factually, it's not taking issue with the matter. So it's effectively
present.
for the moment.
For the moment, yes.
It's acquiesced.
At the moment,
which is not your client's position.
Absolutely, that's the point. And then there's and as we understand, and my learned friend will find the reference, the government does say it's not going to speak on behalf of my client.
Yes.
In the application at paragraphs 005-26, paragraph 26.1, and paragraph 26.2. It says, the reason for 26. The reason for reinstatement appears from what I say elsewhere in the affidavit. In addition, it is necessary to reinstate opposition because 26.1, currently the facts relevant to interference and collusion, particularly relating to applicants' TRC cases, have not been established. 26.2, there is no credible allegation of interference in any of the applicants' cases or the case of another person. As for collusion, there is no clear allegation of collusion. There are allegations of delay and failures to prosecute, but no allegation that these steps were not taken as a result of interference by a person. Sorry, I may have stated it very strongly,
yes.
But what they really mean is their attitude is the applicants have not made out a case of collusion and interference. But I just took the court to where we say they make those allegations in relation to my client, and my client wants to deal with those. So the government might take a legalistic approach, which is what 26.1 and 26.2 reflects.
Well, 26.8 has the answer.
26.8 says,
which says until the Commission has concluded its inquiry and made findings of fact, it would be inappropriate and improper to argue unlawfulness or constitutional damages in the application. So the present government wants to keep its powder dry.
Absolutely.
Until it sees which way, sees what the outcome is.
Yes.
Your client, on the other hand, wishes to be more proactive, and engage directly and answer squarely the allegations that have been made.
Yes. There's a second reason that alternative is not an answer in law, is that the application that faces the court is that my clients want to intervene as a party. Yes. And the question for the court is, have you met the test for intervention? If yes, the court has no discretion. It must allow my client to intervene, irrespective of the fact that it may later be a witness. I could be a witness for my wife in a dispute in which she is cited as a party. But if I have a direct interest, I can also say, yes, I can be a witness and I also want to be a party. So it's no answer at all to that. It's not an answer in law at all. But as we say there at paragraph 16.3, they may well take the attitude that we've lost immunity as a government official. Because, and it was decided in the Zuma case, DA versus Zuma, about the payment of legal costs for President Zuma for the criminal prosecution, that the state is involved if there's a public interest involved. There's a public interest in ensuring the rule of law, upholding the rule of law. If this conduct is intentional interference with the rule of law, breach of the rule of law by stopping prosecutions, there's no public interest in spending public money to protect my clients. So, in other words, as we say at the end of the sentence, we may be exposed to loss of indemnity from liability as former government functionaries. Such a risk has far-reaching implications for our legal rights and financial interests, because somebody else, other than this applicant, might want to sue us personally for the conduct.
Well, if the numbers are anything to go by,
yes, these are huge numbers. Yes.
Hundreds of.
Somebody might have lost a breadwinner. Yes, of course. They may have a loss of support, emotional distress, all of those claims that are available in our law of delict. So this order has far-reaching implications for my clients. We are not suggesting that this court is going to hold my client personally liable, which is what they are suggesting. We are suggesting that the order is the gateway to that possibility, that risk. And so my clients must be there to protect himself and herself against those risks.
Otherwise, you face the same situation that you have here, where untested allegations are then presented as fact.
Yes,
Uncontested allegations.
Uncontested.
Untested and uncontested. Presented as fact.
Yes.
Upon which liability is then said to have been established.
yes. So they say repeatedly,
I mean, it's a muzzle in effect.
it's a muzzling effect, yes. They say Rodriguez, the court in Rodriguez made damaging findings about interference. We said nothing. They forget that if we had tried in Rodriguez, they would have been able to argue better the Zuma position, that NDPP versus Zuma, that we're just a witness. The case doesn't turn on our facts, because he is saying that he is going to suffer injustice because of the delays, and there must be a permanent stay of prosecution. But here, the context is different, and that's why we are before this court. And finally, we say at paragraph 17, the allegations made against Ms. Mabandla and I, if upheld, albeit false, will unjustifiably breach our right. That's the development of the common law. Let me leave that for the moment, not to confuse matters. And then, my Lord will see at page 00, I'm not going to elaborate again on everything, but 004-43, again, the applicants come back to the reasons for seeking intervention. They say at 35, I repeat that I have stated above, what I've stated above in summary regarding our interest and substantial interest in the subject matter of the main application. What I say below does not detract from what I have already said. Ms. Mabandla and I beg the court's leave to intervene in the main application to protect at the very least our respective right to dignity, which is protected by Section 10 of the Constitution, and to have our dispute of the Kalata applicant's serious and damaging allegations against us determined fairly in accordance with Section 34 of the Constitution. This we intend to do by challenging the tarnishing allegations against us that underpin the Kalata applicant's request for a declarator and for constitutional damages. Permitting us to place our respective versions before the court would add to the body of evidence that will have to be evaluated and tested in order for the court to determine the true factual position, apply the law to the correct facts, and thus issue the correct outcome. So it impacts the outcome in the circumstances, as well as appropriate relief, impacting the relief, duration, and the like, including that regarding the establishment of a commission of inquiry now has been established. Absent our versions, the allegations in the founding affidavit would be taken as given. There would be no contrary version before court. There would also be no other opportunity to challenge the Kalata applicant's version, including by way of appeal. So that's the muzzling. And then they go on to set out in brief the evidence that they want to present, but in summary only, because they would set that up in fully when they are asked to intervene. They reiterated this position in reply, my Lord, when they were told they are just a busybody witness who wants to come and set the record straight. And they then come back at page 004-124. They said, where they say there's no relief against the interveners, and they only want to challenge tarnishing allegations. Then in reply we say at paragraph 34, 004-124, rather we seek leave to intervene because the relief sought by the Kalata applicants is expressly predicated on allegations of unlawful conduct purportedly committed by us and other state officials during our government tenure, allegations which we intend to dispute. These allegations have to be determined by this court to grant the relief the Kalata applicants seek. That is the only reason why the Kalata applicants made the allegations which they have not withdrawn. They cannot conveniently attempt to disavow this now to deny us a fair hearing. Our purpose is to demonstrate why, insofar as the conduct is attributed to us, the applicants are not entitled to the relief that they seek. It is evident that we therefore have a direct and substantial interest in the outcome of these proceedings. As we submitted, the relief does do something to our rights. And we carry on that. But that's the basis for the intervention. And we submit with respect that the intervention should be granted on the common law position as articulated in Libya, confirming Wayne, which is firstly direct and substantial interest in the very relief which implicates our conduct, and the duration will be impacted by our evidence, firstly, and secondly on the basis that the allegations of which we complain and which we want to respond to and raise a dispute against to be determined by this court in order to grant relief. And on that basis, the intervention application should be granted. The development of and the Commission of Inquiry, my Lord, has already kind of telescoped whether the Commission of Inquiry is an answer to our application for intervention. That it is not an answer, because the answer is whether we've made out a case, but also the findings of the Commission of Inquiry will not be binding on this court, and the court will still have to make the determinations relevant to granting the relief they seek. My Lord, I'm not going to spend a lot of time on the Libya situation, the development of the common law, which was discussed extensively in the Libya judgment. There the court said, if the witness is simply coming to correct adverse findings, there is no basis to grant intervention, and that there is no basis to develop the common law to recognize that situation, and listed a number of difficulties that would raise. But that is not the Wayne situation. Our development of the common law is only if, in our circumstance, we've met the Wayne test, but the court still denies us intervention on the basis that we don't meet the common law
You
test.
say
In
it's in
that
the
case,
interest of justice that your client be given an opportunity to make sure that the court doesn't make an incorrect finding.
yes,
That is the interest of justice, that courts don't make findings based on half the story, as it were, that a court, when it makes a finding, it becomes a fact, and the public can rely on that.
Yes.
The requirement for that is that all the relevant information is placed before the court.
Yes.
You can't control what is put before the court to control findings and outcomes. That's really the nub of
yes,
that. Even if the test isn't satisfied, the bigger issue here is the complaint that if a finding is made, it may well be an incorrect finding.
yes.
I don't have to decide whether it will be incorrect or not. That's not before
Yeah.
me.
It's in the, yeah,
But if there's a risk that a court will be misled into an incorrect finding because direct and relevant evidence which was available wasn't put before it, that would be a failure of justice.
that would be a
And
failure.
that would then, you say, militate in favor of the development of the common law if I find that you don't meet the test.
Yes, but our submission is we meet the test both at the level of just legal interest and legal interest as articulated in the Wayne and Libya judgments. And so we would submit that the court should grant the order for intervention with costs of due counsel. Those are our submissions. I'm just checking if there's anything that... they have asked for punitive costs against us if we fail. We submit, my Lord, that what my Lord can see this is a novel issue.
Yes, but perhaps you can address that question
In reply.
once I've heard from
Mr.
Mr.
Justice,
Chaskelson on that.
as the court pleases.
Thank
Thank you,
you,
my Lord.
Mr.
Those are our submissions.
Mr. Chaskelson, it's almost 11:05. Would it suit you if we took an early tea adjournment and then we can start?
That would be good.
Yes. Let's adjourn till 11:20. Thank you. Court will adjourn.
Can I tell you
then please explain the law to show why they have an interest they are conflating
justified. But that doesn't give you a right to intervene. And they said that to the very individual who's seeking to intervene here. Mr. Mbeki and Ms. Mabandla, and I would emphasize we're talking about Mr. Mbeki and Ms. Mabandla because they come here in their individual capacity, seeking to oppose relief that is sought against representative defendants in relation to offices that they once held. But they come as individuals. They have no link to those offices anymore. They, as individuals, have no interest whatsoever in the relief sought by the applicants. They are not affected legally if this court grants the declaratory relief that government and the various ministers in their representative capacity, the departments, essentially, unconstitutionally refrained from prosecuting the TRC cases or interfered with the NPA in that regard. They are still less affected in legal terms if this court, when we finally get to the merits in a later hearing, awards constitutional damages to the applicants as a result of unconstitutional conduct that the applicants are able to prove. And they actively welcome the appointment of the Commission of Inquiry, so they have no interest in that relief. So they can't intervene in these proceedings merely to dispute specific allegations made about them in their individual capacities. Litigation, my lord, would become a complete free-for-all if anyone against whom allegations were made, damaging allegations were made in litigation, could participate in the litigation as a party to set the record straight. It would be a recipe for disaster, and we will illustrate it with reference to this case, because contrary to what my learned friend says, a very small net, it's not a small net at all. It is a very wide net of individuals who are alleged to have misconducted themselves. And on the logic of my learned friend's argument, every one of those individuals could jump into this case as a party and could say, wait a minute, you say I did this at that meeting. Well, I didn't. And I now want to have a separate hearing inside this hearing simply to clear my own name.
But isn't it wider as far as the current applicants are concerned?
With respect, not. And I do need to, I'll explain, well, I'll come to this issue in due course. But it is definitely not wider. And there is, maybe I should anticipate it, my lord. There are, when the founding papers were framed, they were framed for the purposes of the relief that is sought. This intervention application focuses only on the declaratory relief and the damages relief to a certain extent, but mainly the declaratory relief. What it doesn't look at is the claim for the appointment of the Commission of Inquiry, which to a certain extent has become moot, not entirely moot, but in large part moot. It's with reference to that claim that one finds in the founding papers very wide-ranging hearsay allegations against a range of people, but in particular against Mr. Mbeki. That's because those allegations are relevant to the appointment of a Commission of Inquiry. We're not foolish enough to assume that this court would think that an allegation in a book is admissible evidence against Mr. Mbeki well, not against Mr. Mbeki, against the government in relation to a claim that the presidency did this or that at a certain time. But it is, with respect, relevant to the Commission of Inquiry, because if you look at a situation where there has been, on everybody's understanding, an egregious failure to take these prosecutions forward in breach of a fundamental promise that essentially underlay the transition to democracy, and then you see that there are a whole lot of people writing articles saying things purporting to have facts as to why this happened. That is relevant to whether a Commission of Inquiry should be appointed or not. We don't begin to suggest that what Mr. I think Ebenezer writes in his book is now going to found a claim for damages. We know the rules of evidence. But what Mr. Bebeneza, and I apologize to him if I'm getting his name wrong, I suspect I am, what he says in his book in the context of what we see objectively, this grotesque failure to prosecute perpetrators of apartheid crimes, it's very relevant to whether or not a commission of inquiry should be appointed. So what my learned friend has done is he has focused on what are, for the most part, allegations relevant to the prayer for the commission of inquiry, and has said, well, those tend, our plaintiffs lie at the center of those. With respect, he's not entirely correct. In fact, the net is very, very wide, and even in relation to the commission of inquiry, his clients are two of a very wide pool of people whose conduct ought to be investigated at a commission of inquiry, either to vindicate them or to establish that they did commit wrongdoing. But when it comes to the declarator, the applicants are relying on admissible evidence in affidavits made by members of the NPA, either making admissions on the part of the NPA or making allegations as to what other organs of state did in relation to the NPA. And there, the role of Mr. Mbeki is almost non-existent. The role of the presidency is not. The role of the Department of Justice is definitely not. And that is what underpins the case in relation to the declarator against the departments and the presidency. But I do want to emphasize that, this case involves allegations against a wide range of individuals in government offices, and litigation would become a free-for-all. If any time somebody made an allegation against a particular holder of a particular office as part of a claim for relief that doesn't affect that person individually, that person was entitled to come to court and say, I need to clear my name. If you want to clear your name, if you want to set the record straight, you have remedies. The law of defamation is one, and the law of defamation has now developed so that you are entitled to come to court not to sue for damages in an action. You can come to court to sue for a declaration of falsity. So if the concern of Mr. Mbeki and Ms. Mabandla is that, well, we couldn't sue for damages in relation to these allegations because they made illegal proceedings and qualified privilege attaches, you can always sue for a declaration of falsity. And the declaration of falsity can't be answered by qualified privilege because it's not getting to a liability to pay damages, it's getting to establishing the truth to vindicate reputation. So the law provides remedies, but those remedies don't involve jumping into a dispute that isn't your dispute and bringing your personal reputational interests into that dispute. And one can illustrate that with reference to the present case in several ways. The first and most striking aspect is that at the time when Mr. Mbeki and Ms. Mabandla sought to intervene, the main proceedings were unopposed. So what they were trying to do was to turn proceedings for particular relief in respect of which there was no list between the parties. The government wasn't opposing, and which the court could determine on an unopposed basis, into proceedings which were now opposed on an entirely collateral issue, which is unrelated to the relief which was being claimed. So they were wanting to intervene to turn an unopposed dispute into an opposed dispute, even though they had no interest, no legal interest in the relief that was being sought in those proceedings. And they say now, oh, well, we have to do that because otherwise we get tarred with the brush of uncontested allegations. the answer to the uncontested allegations point is don't let people intervene in proceedings in which they don't have an interest. If people want to vindicate their reputations, they have their remedies. They should pursue them. They should, if they see that things have been said about them in the Rodriguez proceedings that are false, according to them, let them come forward. Apply. Come to court in an action or an application against the parties who say those things, Mr. Piccoli, Mr. Ackerman, and the like, for a declaration that these allegations are false. They've stood by and done nothing about that since Rodriguez, which I think was in 2018. But now what they want to do is to jump into these proceedings where they have no interest. And with respect, that's not what the law allows them to do. To compound the matter and to illustrate the absurdity of their position, this is a unique case because in this case they have the unique remedy at this point of a commission of inquiry that has been set up precisely for the purpose of determining who is to blame, or if blame is to be apportioned, and where they can have their reputations vindicated. So they are in a much weaker position than the ordinary plaintiff who wants to intervene in proceedings to say, my reputation is at issue here, so I want to set the record straight. There's been a vehicle created specifically for the purpose of setting the record straight.
But isn't there a discord if you have the inquiry and the entirety of the case is going to be decided once the inquiry is concluded, and there are findings and so on? That's one situation. But the applicants here, the main applicants, want an inquiry, and we'll see whether or not you vindicated and what comes out there. But leave that aside, we want damages now.
Indeed.
So what would happen if the damages claim is successful on an unopposed basis? The government's ordered to pay the damages that are sought. It's a substantial sum of money, but
Indeed.
No amount of money can compensate for what's happened here. I think one must accept that. But it's substantial nonetheless, given the constraints of the society we're living in the current time. 115 million rand. We'll just use the one figure.
Indeed.
So you get judgment for 115 million rand predicated on the case as it's presented, unopposed.
Unopposed, indeed.
Then you say, well, the Commission of Inquiry will then find, but hold on a second, the government should never have been ordered to have paid this money because, in fact, there's no basis for it. That'll happen afterwards.
That may happen afterwards, but with respect, we would argue.
Yeah, but let me just finish. And then running in parallel with that is, oh, well, the Commission of Inquiry has found that you ought not to have paid that money, but the order establishing the obligation to pay represents, this is the case for the applicants for intervention, represents a finding, an adverse finding against them. So you say, well, the answer is then to beget more litigation and come afterwards and say, well, now you'll bring an application for a declaration of falsehood in respect of a judgment of the court, which wouldn't have been taken on appeal and in respect to which no one would have intervened. Is it possible to do that?
Well, no. I'm drawing a distinction.
Yes.
The vindication, if it's going to come, will come in the Commission. The
Yes.
Commission is set up specifically to investigate whether there was interference and who was responsible
Yes.
for it. That is the central investigative, or those are the central investigation the Commission has to determine.
You say the applicants, this isn't about money for the applicants, this is about something far more fundamental and profound,
Well,
which I accept.
Indeed, the money is to go to
Yes, to
memorials,
foundation.
to
Yes.
fund inquests, to fund prosecution. It's not money in the pocket.
So
as it were.
why then, on a practical level, isn't the damages claim postponed until after the inquiry? Because there may then be no dispute.
Let me answer that,
Yes.
my lord, because I mean it's foreshadowing what comes later.
Yes.
But we're talking about people who lost their loved ones 40 to 50 years ago. Many of the people who were originally part of the group that the applicants represent have passed away. In terms of the people who were directly connected to those who were murdered, the parents in particular, the spouses, those people do not have long to live. We know the history of commissions of inquiry. I mean, I don't want to give evidence from the bar, but I have the unfortunate distinction of having been an evidence leader at the Marikana Commission and at the State Capture Commission. Both of those commissions started out with very ambitious timeframes in which to report. Both of them ran, well over twice as long, in some cases 3 times as long as they were. In this case, we have a commission that has to make findings which the commission itself can make, and that will offer some indication. It has to make recommendations in relation to constitutional damages. The President then needs to assess, can only make a recommendation on constitutional damages. The President then needs to assess, does the President want to implement that recommendation? Our view, and it's going to be fought out in a week's time, is even if the President decides, yes, I do want to accept this recommendation, he doesn't have the power to treat the National Revenue Fund as his own charitable foundation out of which he can just pay constitutional damages. There will have to be a legislative structure authorizing those payments set up. That will involve a parliamentary process. We don't know what Parliament's going to do. The whole process of finalizing a hypothetical entitlement to constitutional damages through a commission process is fraught with a range of uncertainties and the very real likelihood that it will take a long, long, long time.
Well, that's the one aspect. The other aspect is that the Commission finds that, yes, there were delays, but those delays weren't actionable qua constitutional damages. Yes, there was a breach, but no one set out to subvert the rights of those. It happened, and one accepts, given the passage of time, that it occurred, but that no one set out to subvert. So if they find that, then the damages part doesn't come into play.
Well, then they may say, well, because of this, we don't recommend damages.
Yes.
But this litigation, which preceded the Commission,
Yes.
Long preceded the Commission and in some respects triggered the appointment of the Commission, will have to be determined on its own merits.
Now what they call the Unterste
Indeed.
is, you have in this case a former head of state and minister. One knows, one looks around at travesties across the world, and one of the biggest problems is getting former heads of state and government functionaries before the court. They either disappear or nature takes them. Mr. Mbeki is not a young man. You have an opportunity he wants to come and give direct evidence about things that he knows specifically about.
Indeed.
Pertinent matter that is raised in the papers.
He can go to the President's legal team and he can say, I have all of this information.
Yes.
You're on the threshold of either agreeing to a damages award that shouldn't be made. I mean, I don't understand Mr. Mbeki to be saying no damages should be awarded, but if that is his case,
No,
then
I
say it
didn't
loudly.
understand it to say either.
But if that were his case,
Yes.
I'll invite Mr. Maneche to announce that, but let's assume it was his case. He would then be able to go to the President and say, you're about to make a very ill-considered decision disposing of public funds in an irresponsible fashion on the basis of allegations that are false. Here is my evidence. I am at your disposal to put forward an affidavit. Nowhere in his affidavit does he say that he's done that. He says, oh, well, if I were to do it, maybe the President wouldn't accept my affidavit. The President is,
Well, they weren't defending, and now they
now they
want to
are.
defend. So the position is a somewhat fluid one. But
Indeed. But if they weren't defending, then we're squarely in the Libya the Libya and Win situation where there is no list and he's trying to create a list, and so he has no right.
But we know here that
Now they want to.
defend, so that's on the cards.
But I do want to, I apologize, my lord, but I do want to emphasize this point. We hear all sorts of hints and suggestions, but nowhere do we hear from Mr. Mbeki, I have this evidence, I have made it available to the team on the other side. They've said they don't want to speak to me. They're not going to use my evidence. If he were to want to intervene on that basis, to prevent a miscarriage of justice, a travesty, a waste of public funds, then the time to do it would be when he could come before this court and say, as a witness, I have done my utmost to put the facts before the court.
But then he finds himself in the Zuma conundrum, where he's just a witness and he's got no further recourse other than perhaps the declaration of falsehood.
And the commission,
Yeah.
and a defamation suit against people who repeat these allegations outside of the court.
Where's the how can it be that there's that the litigation would be subverted if the very people who are alleged to have carried out certain specific acts which set in motion a chain of events, which it's not in dispute what the ultimate outcome has been, which is a failure. But the applicants for intervention say, we did not, this is not our brainchild, we did not conceive of a pernicious plan to protect those guilty of crimes for whatever reason. They say we didn't do that. The fact that there have been delays and that it's a travesty, we accept. I read that in the papers. There's no attempt to minimize or to undermine. It's a very targeted, very specific issue. Now, I suppose you foreshadowed it. If the allegations against Mr. Mbeki and Ms. Mbandla were withdrawn, that they specifically conspired to intervene and to frustrate prosecutions, and you relied solely on all the other information, then you're quite correct. We wouldn't be here. But those allegations are still there.
But those allegations, they oppose those allegations.
Yes.
We wouldn't be here precisely because they are only here to vindicate their reputations. That's what they're here to do, and
That's the one aspect. But then the next aspect is that as a sine qua non for the damages, however one characterizes them, but call them constitutional damages, that plan that is said to have been put in place during that period is the causative event for the 17 years of neglect and failure which followed. Without what happened during Mr. Mbeki's presidency, how do you account for the subsequent delays? There's reference to Mr. Simelane and this one and that one, but the case is really the fulcrum of the case, as far as the damages aspect is concerned on the declarator, sits on the shoulders of Mr. Mbeki and Ms. Mabandla.
with respect, it doesn't, Lord. And maybe I should take your
perhaps let's go through that, because
let's go through that.
if I've misread it or I'm getting the wrong end of the stick, then that's why I raise it with you, so that we can debate it.
Absolutely, my lord. Can I suggest that possibly the easiest way of doing this exercise is to look at the chronology that
Yes.
is on case lines, starts at case lines 12-25.
Yes, I have
Okay.
it. Yes.
So, the problem that we allege in this case is a problem that arises in 2003.
Yes.
And if one goes to 01226, you'll see that in the period May to November, the NPA Priority Crimes Litigation Unit, tasked with prosecuting the TRC cases, is denied investigating officers by both the Directorate of Special Operations, that's the Scorpions, and the SAPS. So already as early as May, they've just been given no investigating officers, which means that, save in respect of cases where there is already an essentially complete docket, they can't do anything. In May, A moratorium is allegedly placed on the investigation and prosecution of the TRC cases until new prosecution guidelines are devised. This is not something that's put at the door of Mr. Mbeki and Ms. Mabandla. 2004, 2 entries down, government created an interdepartmental body known as the Amnesty Task Team, tasked with determining how to deal with the politically sensitive cases. That Amnesty Task Team has representatives from the Presidency, Justice, the Police, National Intelligence, and the NPA. 2004, a secret report of the task team considered various options, including a further amnesty, and proposed the creation of an interdepartmental task team to oversee the handling of the TRC cases on a case-by-case basis. Other measures proposed including adjusting prosecutorial discretion using the pardoning power. Let me just stop. This is the task team. Neither Mr. Mbeki nor Ms. Mabandla was a member of the task team. Members of their departments were. What they are proposing is an interdepartmental task team to oversee the handling of the TRC cases. Now, that is a fundamental violation of NPA prosecutorial independence. It's the police, the intelligence services, justice, and the presidency saying, we'll keep an eye on you in relation to these cases. Not these two individuals personally, but members of departments at the head of which they sat in a representative capacity. A further next item, a further report of the task team explored ways of eliminating private prosecutions and civil litigation in respect of the TRC cases, and recommended that the interdepartmental committee work under the direct supervision of an interministerial committee, and proposed that all involved in these efforts, including the MPA, must comply with the national interests. Again, these are people in the administration, not these two individuals, but others, flagrantly violating the independence of the NPA. November 2004, 2 down. Senior official in the Department of Justice called Ackerman SC to stop him from effecting arrests in the attempted murder case of Reverend Frank Chikani. That's someone in justice calling a prosecutor saying, don't perform your prosecutorial function, don't arrest this person. Someone in justice who isn't Ms. Mabandla, but it's someone in her department. December 2005, amended prosecution policy for TRC cases becomes effective. The amendments provided for further criteria to decline to prosecute, which included the TRC amnesty criteria. So we've now got the NPA itself creating what turn out to be unconstitutional policies to govern these matters. 2006, according to Piccoli, that's in his affidavit, attempts are made by SAPS Commissioner Jackie Salebi to have Ackerman SC removed from the TRC cases. So someone in police is trying to get rid of a prosecutor who has expressed an intention to prosecute these cases. 2006, Ackerman SC alleges that DSO, and where we refer to Ackerman and Piccoli, we're talking about their affidavits that they put up. Ackerman SC alleges that the DSO, the Scorpions, and the police persist in refusing to provide investigators for the TRC cases. So we are white-anting these prosecutions from outside the NPA. 2006, this one is sufficiently important that it's probably worth going to the source. What the chronology says is, well, let's look at the sequence. First, it starts with Piccoli informs the suspects in the Chikani matter, and the Chikani matter was a prosecution for those who were clearly involved in the attempted murder of Reverend Chikani, of intent to prosecute. Shortly thereafter, Mr. Piccoli is summoned to the home of Zola Skweyiya, then the Minister of Social Development. I mean, social development, what has that got to do with anything here? And if we can go to page 001 566, if my reference is right. 568. Which is Mr. Piccoli's affidavit. And there he describes what happens there. And I'm just getting the precise annexure, the precise reference. If one goes to 579, paragraph 32. Later in 2006, I was summoned to a meeting which was convened at the home of Minister Square, the then Minister of Social Development. The meeting was attended by the Ministers of Safety and Security and Defence, Minister Toko Didiza, who was Acting Minister of Justice and Constitutional Development, representing Minister Mabandla, who was indisposed. So Minister Mabandla wasn't there, somebody else was there. And Mr. Jafta, who I understand to be, was he the DG in Justice at the time?
He was the Chief Director in the Presidency.
Chief Director in the Presidency. I apologize. At this meeting, it became clear there was a fear that cases like the Chikani matter could open the door to prosecutions of ANC members. I quote hereunder from my affidavit filed before the Ginwala Commission as to what transpired at this meeting. The Minister of Safety and Security was concerned about the decision to proceed with the prosecution, and with Advocate Ackerman's involvement in the process, an issue of whether it was Advocate Ackerman or me who was behind the decision to prosecute. The person who's in charge of taking these prosecutions forward is Advocate Ackerman. He's doing his job, and there is a concerted effort to stop him doing his job. The Minister of Social Development was concerned about the impact of the decision to prosecute on the ranks of ANC cadres, who were worried that a decision to prosecute in the Chikani matter would then give rise to a call for prosecution of the ANC cadres themselves, arising out of their activities pre-94. The Minister of Defence had concerns about where the decision to prosecute rested. Did it rest with me or did it rest with Advocate Ackerman? I explained to the ministers that the decision to proceed with the prosecution rested with me, as did all other decisions in regard to post-TLC prosecutions being considered by the PCLU. I assured them no prosecution would be undertaken without my specific direction, and I reiterated my concern about the delay in the process, particularly in view of the requirement that I report to Parliament on these matters. The Minister of Defence appeared satisfied with my explanation that I would exercise the decision as to whether there was a prosecution or not. The Minister of Safety and Security appeared to continue to be worried about the involvement of Advocate Ackerman. I have no recollection of the particular position adopted by the Acting Minister of Justice. But here we have a series of cabinet ministers doing something that is patently unlawful, trying to stop the NDPP, calling the NDPP to a meeting at somebody's private home to interrogate him about what he's doing in relation to certain TRC prosecutions, and expressing concern that the prosecutor who's taking these matters forward may not be under sufficient control. It is a flagrant violation of NPA prosecutorial independence. If we go across the page, the PCLU was notified in writing by the head of SAPS legal support that no prosecutorial decision, this December 2006, could be made on the TRC cases by the MPA until the task team had submitted a final recommendation to the Committee of Directors General, who in turn would communicate to the NDPP. So someone inside the police is telling the NDPP that you can't take any of these prosecutions forward until an interministerial committee of interdepartmental committees of directors general in other departments who are supposed to steer well clear of prosecutorial decisions and respect your independence has decided whether you can do this. And then 15th of February 2007, at the end of all of this, we finally find Ms. Mabandla getting involved because she's the recipient of Mr. Piccoli's memorandum, where he sets out in chapter and verse how he is concerned about what's being done with all of these NDPP. it's at that point, in 2007, that Mr. Piccoli is removed from the scene. And we don't suggest it was done to neutralize these prosecutions. In fact, I think the historical record shows that it was done to neutralize the prosecution of Mr. Salebi. There is a case in this court that I argued it on those grounds when Mr. Salebi tried to stop that. But September 2007, shortly after Piccoli's suspension, Ackerman SC summons to the office of the new acting NDPP, Mr. Mshe, and he was told you can't do anything about the TRC cases anymore. Later down at the bottom of the page, May 2009 to January 2010, this is already, I think, after the terms of office of Mr. Mbeki and Ms. Mabandla had ended. At the foot of the page, Advocate McAdam of the PCLU, again, this is an affidavit of Mr. McAdam, enters into negotiations with the SAPS to try to persuade them to investigate the TRC cases. Following the appointment of Mr. Similani as NDPP in December 2009, Advocate McAdam is assigned to non-TRC cases. 12 January 2010, Advocate Similani, the new NDPP, confirms at the Justice Committee, Portfolio Committee, that the NDPP are not prosecuting any TRC cases.
Well, it doesn't sound until after the World Cup.
Sorry, until... Was that until after the World Cup, or was
Well,
it...
It's written there at the top of page 012-30. Not prosecute until after.
Yes, I'm not sure that the... Well, I'm not sure that the 12 April entry where there's the report to the Justice Committee meeting is hedged by that, but I can't make that submission with any certainty.
But all of those things are after the...
Indeed.
After the relevant period that's...
Well, after the period that affects...
the applicants.
The applicants. But I do want to emphasize that the suggestion is that the applicants, it's only the applicants period that is targeted, but that's not so. If one goes through this timeline, one sees that in the period, for instance, there's no mention of the TRC cases in the NPA annual reports between 2010 and 2016. There's no mention in the Justice Portfolio Committee. The whole thing has been shut down, and
yes, I don't think there's any dispute from the applicants as far as that goes. It really hinges on
the period
that they were in office and the various books and articles which put them in the direct spotlight.
Well, for the purposes of this relief,
yes,
as opposed to the original Commission of Inquiry, or the purpose of the relief we will pursue before the court. I can safely say we're not going to rely on any books and allegations in books against against Mr. Mbeki or Ms. Mabandla.
But Mr. Chastelson, you've come on oath on motion proceedings for these damages.
Indeed.
So what's there is there.
No, but what's there was there in the context of a prayer for an order directing the appointment of a commission of inquiry.
It's part of the overall background. The moving finger writes.
The moving finger does write.
And it's there now. It can't, unless your clients say, we want to stand down, we want to file a withdrawal of those particular allegations against Mr. Mbeki and Mr. Mabandla, they're going to stand and they're going to be seen and they're going to be evaluated, and that's the gripe.
No, I understand that.
If you say it's not central to your case, then the cancer can be removed and they fall out of the picture.
I may get an I'll have to take an instruction on that. I can't
Yes,
abandon
it just seems to
there,
me-
there are allegations, but there are allegations that are admissible against them, made by Mr. Piccoli in particular.
Well, Mr. Piccoli made affidavits in other litigation, which they weren't party to, which, as to the fact that he made the statements, well and good, but as to the truth of the statements, on motion proceedings, I don't know how one makes any assessment of that. When you
Well,
have
if
the
the-
counterparty saying, "I want to tell you my side," and you say, "No, we don't
No.
want."
What I'm saying is, I have a list not with you.
Yes.
I have a list with government. Government can decide whether they want to settle with me, whether they want to oppose me or not. My list is not with you.
Yes.
If you have facts that you think government really should be bringing to the attention of the court, go to government, give government those facts. Government will then choose. The role of the courts
Yes,
is...
but if one follows that procedure, and I understand why you argue so strongly for that, because that puts them back into the Zuma position, where basically people can say whatever they want about you in court proceedings, as long as they don't ask for a finding against you or for money from you. They can say what they please, and your remedy is to find yourself stuck in the mire of the court system, applying for declarations and so on, while while that case goes ahead. I mean, it can't be that and I'm not suggesting that it's being done deliberately, but it can't be just that people can say what they wish about you, and your remedy is to come to court later. What if you don't have the means, as millions in our country don't? We just happen to have two parties that have means to say, well, we want to get involved.
Well, if you don't have the means, then you don't have the means to intervene. So you...
No, yes. So what happens is they then left with the Zuma situation, where findings are made against them. They could do nothing to stop it. It doesn't help to say, well, we'll solve the health crisis in the country and the lack of beds in the hospitals by letting all the patients die. And when we don't have patients anymore, then we've got enough hospital beds and enough doctors. The answer is to address the concern. So when they say, this is not correct, and we can give direct evidence and explain, aren't the interests of justice served by having them under the cosh, so to speak, to answer it directly?
With respect, not, my lord. And it goes back to what the function of courts are in society. The function of courts are to resolve disputes. To resolve disputes between litigants. There is a dispute here between the set of litigants who are the applicants and the respondents. That dispute has been framed in the terms set out in these papers. It's a dispute between the applicants and the respondents, not a dispute between the applicants and Mr. Mbeki. If the respondents want to decide that they are not in dispute with the applicants, then the respondents can settle with the applicants and the dispute goes away. The function of the courts becomes completely subverted if parties who are essentially witnesses, or who could make themselves witnesses because they have something to say, or against whom certain allegations have been made, can intervene in proceedings and turn what is a list between A and B into something very different. A new list between A and C that may sort of distort the old list between A and B.
But they're not creating a new list. They're targeting a very specific aspect of the list between yourself and the government. Whether the government choose to defend that aspect or oppose that aspect is one aspect. But here they say, but there is no basis, and we have the direct evidence. You accept that the government, as it stands, doesn't have that evidence.
My lord, let me use the example, for instance, of a review application. A review application brought on the basis that certain officials in the department acted corruptly. Very, very serious allegations against those officials. The department looks at the record, takes the view it's not going to oppose this. On the reasoning of the applicants, those individuals against whom the allegations of corruption are made can now intervene in the proceedings to say, no, these allegations against us that we acted corruptly are false. Here is the true position. We know it because we were the parties who alleged to have acted corruptly. We want that dispute ventilated on our evidence before any decision can be taken in the dispute between the department and the unsuccessful tenderer. That's a situation that subverts the role of courts in society. What it turns into, I mean, the lesson coming out of this is that courts, on the flip side, courts should be very wary to make specific findings of fact against named individuals in the absence of those named individuals. But it doesn't.
There's a lot of authority on that proposition.
There is a lot of authority, yeah. But it doesn't mean that courts, if there are allegations against named individuals, can't decide the issue in terms of the list between the parties without the presence of those named individuals as parties. Those named individuals can either go to the respondent and give their evidence, in which case the respondent will have their evidence, will use their evidence, and the court will have both sides of the story. But if the respondent, who is the party to the dispute, decides, I'm happy to settle this, or I'm happy to agree to the order, it's not for the court to say, well, actually, although this is a list between A and B, and my job is to determine that list, I proactively think it would be better if C could come and give their version. And so even though A and B are at Eden that there is no longer a list and they just want an order, we're going to put this on hold and let C come and have their say. What the court's responsible position in that situation is to say, there are these allegations. They haven't been answered. The parties against whom are alleged to have committed the wrongdoing have not put affidavits. I haven't seen affidavits from the parties alleged to have committed the wrongdoing. So I'm not going to make findings against any named individuals. But on the evidence before me, I have to conclude that there was wrongdoing. I'm not going to say X was guilty of wrongdoing or Y was guilty of wrongdoing, because X and Y's affidavits aren't here. But in terms of the evidence before me, for the purposes of determining this list between these applicants and that respondent, the evidence suggests that parties for whom these respondents are today responsible were guilty of wrongdoing. And that's really all that we will be asking the court to do in the main application. And I do, at this point, want to go to the law, because there are two the law we submit is quite clear in this regard. But before we get to the law, I want to emphasize that in approaching this case, one has to draw a very clear distinction between a representative defendant and an individual who once occupied the position of that representative defendant. In this case, the defendants are all sued in their official capacity. We're not suing the president or the occupant of the position of president or the occupant of the position of the Minister of Justice. We are suing the Minister of Justice, the President, the Minister of Police, the Minister of Defence in their official capacities. That's, it's trite, Lord, but it's there in the founding affidavit from page 35 onwards. The applicants in this case are Mr. Mbeki and Ms. Mabandla. They can't complain if orders are made against the representative holders of offices that they once held. There is a distinction between the representative defendant. It's like the Minister of Police who retires can't come back to court today and say, well, look, I see that while I was in office, one of my policemen shot a protester who's now suing the Minister of Police for R1 million. I want to intervene because in the course of this application, there are certain allegations made about what I did or didn't do personally while I held that office in relation to standing orders on crowd control. And so there's some allegations made against me. And I held that office at the time, and the order is sought against that office. That would be laughed out of court. But essentially what's happening in this case is no different. What they're saying is there is declaratory relief sought against the holders of the office of President and the holders of the office of Minister of Justice. There are certain allegations, not exclusive allegations, but some allegations made against me individually, what I did individually when I was holder of the office of President, and what I did individually when I was holder of the office of Minister of Justice. And because of that, I now have an interest in the relief sought against the representative defendant. But they don't. Relief against a representative defendant is wholly unrelated to relief against an individual.
You don't think that perhaps the context of this case has a slightly different blush on it? If the allegations are made, if the allegations stand unanswered, besides what can happen at the Commission of Inquiry and so on, but in effect, given our particular history within the country, it's not just a simple matter of allegations that were made against me that were false. It's the mark of Cain, effectively. And your papers make that clear. It's something that goes beyond just a functionary who failed to fulfill their function or didn't understand properly their role in carrying out the law as it was, or even just a dishonest person. This is the way it's cast. The particulars is a number of paragraphs where there's specific allegations made. Now you've disavowed reliance on those specifically.
Well,
you say look at
the books. And
yes.
Books. Yeah. We're not relying on the books for this.
Yes,
for
but
this stage.
But there's certain allegations regarding a conspiracy, if one wants to put it in those terms, although you don't cast it in that way specifically, to subvert the completion of the work of the TRC through prosecutions and so on. That's a devastating allegation. I think just historically, there's not many people within the country who would ever have to face such an allegation and then have to deal with it. It's something that perhaps no court could ever, you could never get redress from it. Is that not something different, that the facts here are such that it cries out that the direct answer from the parties said to have been there and been responsible is called for? Of course, it may assist your client. Ultimately, the explanation may cast new light on other things of which you're unaware, acting out of self-interest, which they no doubt must. To exonerate themselves, they may be able to give other information which isn't contained as part of the public record and so on. But for the moment, the mark, if an order is granted and those allegations are not answered,
well, several answers, my lord. My primary submission is that one must have a principled approach to this case. One cannot say because the damage to your reputation is so big, potentially so big, we're going to let you intervene in this case as a party, whereas other people who can show very serious damage to their reputation, but not quite as serious as this, can't. There has to be a principled approach to the whole issue. But there's a simple factual answer, which is these allegations are broadly on a par with those that were made in the judgment in Zuma, where Mr. Mbeki sought to intervene in the SCA. And those allegations
and he was
were
shown the door and said, well, you've got no interest. Now he's back again and says, well, I want to explain. I must tell you, and it's not, the case will be decided on the law, and I haven't made up my mind. But what weighs in my mind, the overriding factual basis of what's happening here, is that we all know that apartheid was declared a crime against humanity. We all know. So when an allegation is made against someone that they acted in a way that either sought to deny victims of apartheid justice or furtherance of the interests of those who were perpetrators, because that's really the crux of it, that what's been said about generals and attempting to control the process to protect themselves and those who were perpetrators. It's something on a level which the ordinary civil law doesn't ever really get to. It's not a matter of a simple stain on one's character that can be rectified. It's something which actually goes beyond. It's in a category, it's sui generis, as far as the consequence of an unanswered finding. How does one deal with that? If one took the view that the facts of this case, fact specific, perhaps this is the development of the common law that Mr. Mainecha is argued, that the particular facts, given our particular circumstances, our constitution, the preamble to our constitution, that this is something unique. The family certainly contended to be so, given the case. So they don't dispute that. And that's the source of their justified dissatisfaction and unhappiness. I can say that. I think it's quite clear. But the question is, where does the finger ultimately, where does the buck stop? And if the buck stops based on allegations that haven't been answered, it carries with it imputations from which no normal person can recover. Why should you be denied the right to have your say? It's not going to delay matters for years. It's 17 years since the applicants left office. It's waited 17 years since they left office. What prejudice can there be to them saying to the court, this is what happened?
Well,
It's a lot of different points made.
No, no.
Sorry, Mr.
Well,
I was thinking aloud.
sure.
Yes.
No, my lord. I mean, I need to answer them all.
Yes.
And unfortunately, I wasn't writing them down.
Yes.
But the first point is that it is an exceptional case. Partly because it's an exceptional case, one needs to keep the list very firmly defined. So if government is willing at a certain point to reach a settlement with the respondents or to narrow the ambit of the dispute in particular ways, one needs to leave that to the to the applicants.
Yes.
One needs to leave that to the applicants and government. One shouldn't let a third party whose own individual reputational needs drive their process potentially interfere with the primary list. The flip side of that is that the court ultimately deciding this matter needs to be alive to the fact that it may be called upon to decide it in the absence of a version from Mr. Mbeki or Ms. Mabandla. If that is the case, it should be very careful to frame whatever findings it makes in terms that make clear that it hasn't heard from Ms. Mabandla and Mr. Mbeki. And so it cannot be assumed that they may not have something to say on this.
But
So
isn't that then the crux of it, the audi altrum?
No,
If any finding is to be made, and they want to be heard, they should be allowed to be heard.
No, my lord, because the dispute is not with them. The dispute is between the applicants and government. And it goes to the fundamental role of courts in society. Courts are not there. Courts are there to determine disputes, and the disputes are defined by what the parties to the dispute put in issue. What that means is courts frequently hand out orders between parties that are orders which, if all the facts were known, the courts wouldn't hand down. And the court's job would be subverted if the court went beyond the parties to the list and the actual dispute, to start looking at interests of third parties who are not parties to the list. What the court's responsibility in that context is to make sure that when it determines the list, it doesn't do so in a manner that can be deployed against the third parties who haven't been heard. Third parties don't need to be heard if they're not parties to the list and they have no legal interest in the matter subject to the list. But if they have a reputational interest, which doesn't rise to the level of a legal interest, as the decisions in Zuma, Libya, Koko, and the series of other cases make clear, court should be very cautious not to frame reasons that can then be deployed against them without their being heard. Court still has to decide the list, which is a dispute between two defined parties, on the basis of the evidence that those two defined parties seek to put before court. That's the first answer. It's the primary answer. It's the answer that I would emphasize. But there is a secondary answer, which is, if in the light of the exceptional circumstances of this case, your lordship might be minded to say, well, let's carve out a once-only exception because this case is so big, or so important and so cataclysmic in the consequences of a finding. Then, two things. The first is, your lordship, in determining whether this case is so big and has such potentially devastating consequences to the intervention applicants, would have to bear in mind, first of all, the intervention applicants are going to have an opportunity to clear their names once and for all before a commission of inquiry. So that is where their reputations will stand or fall ultimately, what that commission determines. That's a commission that's going to investigate these very, very specific allegations against them. It's going to say there was interference or there wasn't interference, and if there was interference, you were to blame, but you weren't to blame. That's those its terms of reference. So it will be much better placed to make the sort of finding that would be necessary to vindicate a reputation than a court, particularly in circumstances where a court can hedge any judgment that it makes very clearly by saying Mr. Mbeki and Ms. Mabandla, I saw no affidavits from them. They wanted to intervene. They weren't allowed to. The presidency and the respondents, for reasons unbeknownst to me, chose not to get affidavits from them. In the circumstances, great caution must be applied into extrapolating any of the findings in this judgment to their individual roles. They've been made without the benefit of hearing. That is perfectly legitimate for a court to do, and indeed appropriate for a court to do, in circumstances where it has to decide the lists, and the parties to the lists, for better or worse, have chosen not to engage the evidence of Mr. Mbeki and Ms. Mabandla. But there is a final point, which is, even if, despite all of that, your lordship is still concerned about fairness to these two individuals, our submission is that if they want their version to be put before court, the ordinary way you put your version before court is through one of the parties. And if they cannot come to your lordship and say, we've approached the respondents in whose interests our version sits, and we have consulted with them and we have told them all of the facts, and for reasons which we don't understand, they choose not to use our evidence. We want to put it forward ourselves. Unless they can say that, they can't subvert the rules of intervention and joinder to get a hearing where they haven't sought to have the hearing through the ordinary processes of court, which are evidence gets put before the court by the parties.
Our difficulty in this matter is this question of the approbating and reprobating by the government, an appearance to defend and then a withdrawal, and now they want to come back. So at the time these proceedings were brought, it was effectively an unopposed application, and they said, well, we can't be left swinging in the wind. There's no one else coming to the party. We would like to come. So subsequent events have changed that aspect of it. But I think it's unfair on the applicants to say they ought to have done that, because factually there was no one.
Yes, but they are still pursuing intervention now when they know that government is opposing or wanting to oppose. And they're not saying, let's stay this intervention in application until we've offered governments all of the evidence that we have, and government has rejected it or refused to put it up. They're saying, let us come in as parties.
Yes, but I think time perhaps overtook the parties here, because now the government, as we know, there's a stay application which is opposed.
Yes.
So your clients, the families, are intent on pursuing the matter.
We are.
They want the matter to be resolved, and they're entitled to that. It's been long. I mean, the time has been quite unacceptable. So they're entitled to insist that the matter proceed. But it brings with it this difficulty now where the ordinary course of things, which may have presented a solution and obviated the need for the intervention, is no longer a viable issue, because the government's not here today to take an instruction to say, well, we're going to file papers in the following way, and Mr. Mbeki and Ms. Mbandla will depose to affidavits dealing with their terms of office, and then so and so, and then so and so. They're not here, so I have to deal with, as you correctly said, I have to deal with what I have here now, which has its own problem.
You do, but my lord, what you don't see in the reply, by which stage government's new position was clear, is you don't see, well, government is now opposing, and we've reached out to them and we've said we want our story told, and we want to give you affidavits. Here are our affidavits, and government has said we're not interested. You don't see that. But even if we go back, if we are to decide this matter on the facts as they stood when the application was launched, well, then the intervention application has an even bigger fundamental problem to it, which is that it sought in circumstances where there was no this between the parties to prevent an order being granted because of a third-party intervention unrelated to the relief that was going to be granted. Assume this was going to be, assume government had stayed constant and said, we don't oppose, we're happy, we consent to judgment. It would have been an unopposed order which would not have needed to make any findings in relation to Mr. Mbeki and Ms. Mabandla.
But there has to be a finding. It's a prerequisite for
well,
the
there would be there'd be a declaration of rights in the representative capacity. But that doesn't affect their rights. What does it say? It says that in the period of 2003 to I think 2009, which is when they left office, which is their period, their concerned period, the presidency and the Ministry of Justice were party to acts interfering with the independence of the NPA. That's not something that...
That's benign. That's a benign characterization of what's been put in the papers.
No.
The papers are far less benign than that.
Yes, but the finding of the court.
Yes, but
in
the
an
finding would
unopposed
be based
application.
on what was there, and the finding would be there was this concerted effort to undermine the Constitution and the prosecution of TRC matters. This deliberate intention, actuated by former perpetrators of crimes and so on, wanting to protect themselves, ostensibly holding the threat of possible prosecution of the incumbents over them, and getting them to acquiesce to this program of, well, we want to prosecute.
That is what is set out in the papers.
Yes,
Indeed. But we come back to the sort of fundamental legal principle, which is that in a list between two parties, those parties determine what the outcome, the list is confined to the two parties, unless a third party's legal interests are implicated. And third parties don't get to intervene in the proceedings to answer allegations made against them on the papers, subject to one possible exception, which is the exception anticipated in Wynne. And it's because the applicants place so much reliance on Wynne, it's worth going to Wynne. Because Wynne is held out for as authority for something that it just doesn't say. The key passage in Wynne, which is ultimately all that the respondents have to pin, all that the applicants have to pin their case on, is the passage that starts at 774. I've now lost my my little letters.
774 E to H.
E to H, indeed. And that's, the first three words are very important. Assuming without deciding. So the first thing that Wynne says is, you've referred me to a whole lot of cases where people could come in and protect their reputation. I'm not saying that's the law. But let's assume that it is, that the above decisions are correct. It seems obvious in each case the reason for granting leave to intervene was that the damaging allegations against the third party would necessarily be an issue between the parties to the litigation. It would have been impossible for the court to give judgment in those cases without deciding whether the third party had or had not committed adultery. I mean, the cases referred to for the platform this statement in Wynne are adultery cases, where there's a divorce action in the days when, long before no-fault divorce, where you had to prove adultery. And the alleged third-party adulterer said, well, I'd like to be heard too, because my interests are also at stake here, or my reputation is also at stake here. You can't find that the spouse committed adultery with X without finding that X was involved in the adultery that the spouse committed.
Yes.
And so in those circumstances, they said X could be heard. It would be impossible for the court to give judgment in those cases without deciding whether the third party had or had not committed adultery. And the effect of the judgment would therefore have been to decide the correctness or otherwise of the attack on the third party's reputation. Same position arose in Mbandla versus Budria, where the defendant alleged fraud and collusion on the part of a third person who was not a party to the action. In principle, the full court accepted the proposition, the man's character being beyond all price, the third party should be entitled to intervene. But this, again, was a case where the allegations made against the third party were directly an issue between the litigating parties and would necessarily have to be decided in the course of the judgment on the merits. So the high watermark of the applicant's case is that, although Wynne doesn't say it, we can actually now accept that those cases represented the law. So while Wynne said, I'm leaving this open, but let's assume they're right, we'll now say we've decided they were right. And what is the principle that flows from it? Which is, when allegations will necessarily have to be decided in the course of the judgment on the merits, the party against whom that allegation is made, who isn't before court, can intervene. But this isn't such a case. I've just taken your lordship to a catalogue of founded allegations of interference in the period 2003 to 2009, which don't involve Mr. Mbeki or Ms. Mabandla personally. They involve officials in their departments.
So why aren't those allegations against them then withdrawn, and that would be the end of the matter? You said earlier you might want to take an instruction on that.
Well,
mean,
maybe when we break for lunch,
if they're not foundational to the case of the applicants.
Well, they're not necessary for the case of the applicants.
Well, that's even better. If they're not necessary, if they withdrawn and struck from the papers, any complaint that the applicants may have had regarding the risk of a finding which would place reliance upon those allegations is removed, and then they will go to the Commission of Inquiry. Would that not... it just seems to me that if it's not necessary for your case, and your course of action is, despite the Commission of Inquiry, we want to proceed to court for the declarator and the damages, then if it's not necessary and it's removed, the applicants have no more reason to pursue the application. It doesn't affect the list, as you say, and I don't know, perhaps that's an oversimplification. I don't know.
I hear your lordship's proposition. My concern is essentially twofold. That we can't be put into a position where we have to take out allegations in our list with a third party,
Yes.
because Mr. Mbeki and Ms. Mabandla don't want us to make those allegations. Their remedy should really be, if what we are saying in relation to them is not true, they should go to the presidency and say it's not true. We want our here are the facts. Put them up. There is a broader concern, which is we make allegations of a more serious nature against a wide range of people, Mr. Simelane, Mr. Salebi, Mr. Jafta, a range of people who are specifically named as interfering and doing specific acts in relation. On the logic of the intervention applicant's position, every one of those could then pop up and say, well, you know, we now realize that you've made these allegations against us. We want to intervene. It becomes a free-for-all. And then to let the next, to let the case proceed without a myriad of other applicants intervening, we're forced to say, well, we can afford to let this allegation go, so you, Mr. So-and-so, can go, but you, Ms. So-and-so, no, we actually absolutely have to hang on to that allegation.
But there are no other applicants. I think I have it on good authority, I can assure you, Mr. Salebi.
No, they're not applicants.
Mr. Salebi won't be applying.
Oh.
I think I can say that without fear of contradiction. But if there's specific allegations, we're not talking about the general body of allegations. There's many things said, but there's very specific allegations which are problematic. It's the allegations relating to a conspiracy and a concerted effort to undermine. You say those are, for purpose of the discussion, you've said those may not be necessary. One can't hold you to that.
No. In relation to a concerted process to undermine, quite clearly our case is that there was.
Yes, but not at the instance of the applicants. You say the passage of time and the record of prosecutions speaks for itself as far as whether it was done or not done and how and so on.
Indeed.
The issue of the applicants is that you say the start of the rot was in consequence of decisions taken directly by them, which formed the basis for what followed. Now, you say that's not necessary because there's no allegation.
We don't say.
Yes.
I mean, contrary
No,
to what about
Yeah.
we're quite careful about what we
Yeah.
do and don't say. We don't say it was in consequence of decisions taken by them.
Yes. So perhaps during the lunch adjournment, you can look at that and just see. It may.
Look,
may come
I
to
will
naught,
I will definitely take an instruction.
But, it just seems to me that the longer one spends in court, the more one realizes that it's best not to be in court. And I think that applies to everybody. If the matter can be resolved in a way that is accommodative of the interests of all concerned, the parties always do keep that in mind, I've no doubt. It just occurred to me while we were having the debate, but obviously I can't hold you to that, but it arose during the course of the debate.
My Lord, I do want to finish my submissions on the law.
Okay.
So I have made my submissions in relation to Wynne.
Yes.
That Wynne would only apply if the allegations to which, if excision of the allegations against Mr. Mbeki and Ms. Mabandla would leave no actionable case, and those allegations would be necessary for the court to decide. I would emphasize in relation to Wynne, nowhere in the proceedings, and nowhere in the jurisprudence is it ever suggested that where a court might reach a conclusion without necessarily determining those factual disputes, it's incumbent upon a party to withdraw, to remove the dispute, to withdraw the allegation before otherwise the court will let the intervener into.
No, I'm not suggesting that. It was simply raised on the basis
as a sensible way of cutting through this.
Yes, the applicants are going to the Commission of Inquiry, I have no doubt.
Indeed.
These allegations have been made. I'm sure they'd make themselves available. But
if one goes then to the Koko judgment, which is a judgment of this division which pulls together all of the leading cases, including several that we hadn't come across. There were much more diligent counsel in that case. But the facts around Koko were essentially these. ABB is a Swiss-German company that produced boilers for one of the Eskom plants. I think it was Kusile, it may have been Medupi. ABB essentially reached an accommodation both with Eskom and the NPA, in terms of which it confessed that it had got the contract by paying bribes to a relative of Mr. Koko. That was the version of ABB. A review application was then brought to set aside the original contract and to put in place, as an order of court, the remedy that ABB and Eskom had essentially agreed to. That review application gave chapter and verse of the alleged bribery. There was a return date provided in the original judgment, and on the return date, Mr. Koko came to court to say he wanted to intervene as a party because all of these allegations of bribery against him are false. The court that had handed down the original judgment prior to the return date had been careful not to name Mr. Koko specifically or to name any of the parties against whom bribery was alleged. And the court then had to consider whether Mr. Koko had a direct and substantial interest in the matter that would justify his intervention, and your Lordship can take it as said that the allegations against him were allegations of extraordinary criminal conduct, massive corruption. The court picked up the argument on direct and substantial interest from paragraph 13, and it explained what a direct and substantial interest means. Paragraph 16, the order and judgment have been quoted above. They contain no reference to Mr. Koko. The court considers that in Zuma v. NDPP, the Supreme Court of Appeal refused applications for leave to appeal brought by parties against whom adverse findings have been made in the reasoning of the court. Zuma NDPP is addressed. On this basis alone, Mr. Koko lacks a direct and substantial interest in the subject matter of the review proceedings. We, with respect, would submit exactly the same in relation to Mr. Mbeki and Ms. Mabandla here. The court then proceeds to consider all of the related judgments. It deals with reliance on Win. Paragraph 26. In any event, the authority in Win is overshadowed by more recent and binding authority on point. Counsel for Eskom and SIU relied on this authority in their written submissions, where they summarized the legal position clearly in relation to 6 authorities. First is NDPP versus Zuma, which we've discussed. Paragraph 29. The second authority is B. Ulu and Partners. Herein, Rogers J. setting aside agreements concluded between the Department of Environmental Affairs and a law firm called B. Ulu and Partners. The judgment by Rogers J. made express findings of malfeasance against public officials in the department. Express findings of malfeasance. These officials applied to intervene in BXI's rescission challenge against Rogers' judgment. The court refused the application for leave to appeal as a direct and substantial interest in the outcome of the litigation is not merely established by the fact that judgment costs aspersions on a person's character. Third is Central Energy Fund, in which, like the present matter, it involved a review, specifically a legality review of the decision to sell off strategic oil reserves. Mr. Gamede, the former CEO of Central Energy, was central to the impugned transaction and was implicated in misfeasance. Mr. Gamede sought leave to intervene as a party and to file an affidavit on the merits, which, as Mr. Koko in this matter, would correct the unflattering allegations made against him. In addition, like Mr. Koko, Mr. Gamede sought intervention on the basis that the judgment may adversely affect his reputation. Reputational harm, the court held, could not justify an intervention application. Fourth, Siangena Technologies, this is an SCA judgment, also involved a review. Herein, PRASA applied to review and set aside contracts it concluded with Siangena on grounds of legality. The review implicated PRASA executives in malfeasance and corruption who were not cited as parties. The comparison can be drawn to the present case in which the parties to the agreement were cited, being Eskom and ABB, but not the employees or officials. The High Court halted the hearing in order to hear from the implicated executives. However, after a postponement, a different constituted court heard the matter, disallowed the affidavits, and upheld the review. So the affidavits were left in. On appeal, they were knocked out. On appeal, Siangena contended that the affidavits should have been allowed. The Supreme Court of Appeal disagreed and upheld the position that the intervening executives lacked a direct and substantial interest in the relief sought by PRASA. The court held that there is certainly no provision in the uniform rules for the intervention of a witness in an application. Fifth is the matter of Deputy Public Prosecutor, in which a new Public Prosecutor, that's paragraph 34, sought leave to intervene in proceedings concerning the erstwhile Public Prosecutor's inquiry. The High Court dismissed the application, holding that as the order did not prejudicially affect the new Public Protector, she'd failed to establish a direct and substantial interest. Sixth, the Constitutional Court rejected reputational interest as a basis for intervention in Libya. And then in paragraph 38, now, my Lord, I'm not sure, but I think that this is a judgment of your Lordship. Counsel for ABB referred the court to a recent decision of this division in Kutzer versus Office of the Chief Justice, handed down by Miller J. on 13 May 2025. The facts of this case were that the applicant sought leave to intervene in an application for self-review of a tender awarded by the Office of the Chief Justice to Thomson Reuters. Pursuant to the award of tender and signature of the contract, it emerged that the first to third applicants, former employees of the OCJ, had established that the fourth applicant had then submitted and been awarded a subcontract in terms of the main tender. During the currency of the employee with the OCJ, the intervening applicants had in some way been involved in the adjudication and award of the tender, or had knowledge of it. In the filing of its papers for self-review, certain technical grounds were raised as to why the award of tender should be set aside. Additionally, the OCJ, through its then Secretary General, also filed an affidavit in which certain allegations and concerns about the role of the intervening applicants were made. The intervening applicants didn't oppose the reviewing and setting aside of the main tender. In addition, the subcontract between the fourth applicant and TR has also been cancelled. Save for any historical role they played in their erstwhile capacity as employees of OCJ, they have no interest in the proceedings, save in one respect. The allegations made regarding their conduct while they were employees are false and defamatory, and that the making of such allegations without what they contend is any basis was done purely to bring them into disrepute and to harm their reputations and future commercial prospects. So they're actually alleging bad faith allegations here. Again, the striking similarities between the matter in Kutsa and those of Mr. Koko, the factual similarities are striking. In Kutsa, the court held, to my mind, the main review proceedings will be decided based on the record of the proceedings which are under review. This record sets out the conduct of the applicants while they were employees of the OCJ. The court hearing the review will decide the relevance, if any, of the conduct of the applicants regarding whether reviews to be granted or not, and will consider the veracity and appropriateness of any adverse statements made about them in its consideration of the matter. For the applicants, insofar as their past conduct while employed by OCJ is concerned, the moving finger writes and having writ moves on, nor all thy piety nor which shall year it back to cancel half a line, nor all thy tears wash out a word of it. Their position is no different to any past employee of any institution whose conduct while employed is to be considered. The right to dignity is not in issue. Either the grounds of review premised on the conduct of the applicants have merit, or they do not. The application to intervene, for reasons I've given, lacks any merit and must be refused. Now, my Lord, running through all of these cases is the principle that very, very damning allegations can be made against you as an individual in the context of a list between two other parties. That doesn't give you a right to intervene. And if you are a former employee, well then, you are a former employee and you have to accept that the list between your employer and the current applicant will be determined by what they choose to put before court, not what you would want them to put before court. So we would submit, my Lord, that to grant this intervention application would fly in the face of Zuma versus NDPP, Libya, Koko, the four other judgments cited in Koko. It would be a dramatic departure from the established law on what is and isn't a legally cognizable interest that can support intervention. And for that reason, we would ask your Lordship to dismiss the application. Or, my Lord, I see that we've now reached 1 o'clock. I do have one or two closing submissions. I wonder if it would be a convenient time to take the lunch break, or unless your Lordship wants to work through and get the matter done.
We still have to hear from Mr. Maineche and reply. I think let's take a 45-minute adjournment for lunch. That'll give you time to collect your thoughts and wrap up, and then we'll hear from Mr. Maineche. So we'll come back at 1:45.
As your Lordship please.
Court will adjourn.
Inclinations. Second one, you probably might have to develop and where he's going is that this is of such historical significance. Hard to run against your logic. This is I'd just like a cup of double espresso. Make it 2 of those. And a Coke Zero.
Protein bars, some mixed nuts, and some dried fruit.
It's about my protein.
it's not readily available in government archives and other places, are those who were there. Now, yes, it would be ad hoc, but perhaps as ad hoc as the TRC itself, that it's something which must be allowed to see its course. And the monetary aspect of it is being dealt with nomina officio by the state parties. But wanting to hear from the mouths of those who were there, rather than by inference and books and articles and so on, and affidavits filed in different proceedings, isn't it the right of the families to hear directly from a person they obviously regard as being responsible for the predicament, or at least partly responsible for the predicament, what he has to say? Whether it holds water or not is a separate issue. I don't have to get involved in deciding that, fortunately. That's not for me to decide, but the principle of the right to know and the right to hear from the responsible party, is that not sufficiently, given the particular, I mean, it's a very specific fact here. It's distinguishable from these commercial matters and Kutzer and others in that respect, because it deals with something quite fundamental to our society and who we are. It impacts the Bill of Rights, it impacts what's happened in the past. Would that not be a factor which would move you in favor of saying, well, if there must be an ad hoc consideration, although it may well implicate more than the two applicants here today, that accepting that with this type of litigation there may be others who will come, but that there's a catharsis in allowing those who were there to come and say what they need to say. That was one of the purposes of the TRC itself. So it's really a continuation of the process, whereas if one says, well, we're going to make allegations and we're not going to give you your say, it then undermines the whole purpose, where people say, well, let me keep my head down and not put my head up and say what I know, because I'm never going to get a chance to explain it in my own way. And that then leads to part of the problem that we face.
My Lord, two answers. The first is, we're not in that situation because we have a commission. And so the place for the catharsis is really through the commission.
Yes.
And it's a much more appropriate place for a catharsis, because it is a place, well, it's proactively going to investigate. It has powers of compulsion and evidence gathering, which a court or which individual litigants in a court just don't have. And in any event, even if it was just limited to the powers of ordinary civil litigation, it's there. It will provide that function, and there's no need to interfere with ordinary principles about the function of a court, which is to decide a list between the two parties to the list, to accommodate a cathartic process which not only can be, but will be accommodated elsewhere. So if we're looking at it ad hoc, we don't need to do it in this case. But there is a second concern relating to the ad hoc approach, which is, and to a certain extent the floodgates argument, is that this is truly a horrific episode in the history of our country, but it's not the only one. I mean, let's take state capture as an example. I mean, in terms of the betrayal of the promise of a democratic South Africa, in many respects, state capture sits at a similar level to what we're talking about today. You're talking about a situation where the persons presiding over a democratic state essentially surrendered control of very crucial state functions to a corrupt crime family. If one makes the argument that this is exceptional, one really ought to be able to make the same argument that state capture is exceptional. And then one sits in a situation where ESCOM litigates, well, take the ABB case, which is a very good example. ESCOM litigates to recover money which it says was paid under a contract which it says, I emphasize, was corruptly procured through bribes to Mr. Koko. Mr. Koko would have a right to come in there, because essentially what he's being accused of is being part of a broader process where state-owned enterprises essentially abandoned their public purpose for a purpose of enriching third parties. Not on an individualized basis, but on a systemic basis, as part of a broader conspiracy to really redirect the benefits of the state away from the South African public and into the pockets of a very select few. It is a very, I don't think we can, this is, and I don't for a minute underplay it, it is one of the real stains on our post-apartheid history. But there are others.
Yes, but if there are other stains, we accept there are, but state capture and so on. I've no difficulty with how you described it, but there's fundamental differences here. The loss of life, children who lost parents, things that transcend loss of economic opportunity, loss of money, loss of access to services that should have been there because it was provided for but wasn't. It's slightly different. Here the power of the state was brought to bear upon individuals, and devastation ensued. Death and devastation ensued. For anyone, you're going to find it very difficult to find anyone who will admit to having ever voted for the National Party or who will admit to anything. It's just the nature of things. Human beings are that way. So the focus necessarily moves to those tasked with rectifying the wrong. And that's what's happened here, that the focus has moved in some part away from the perpetrators of the injustice to those tasked with seeking to, or those tasked with redress. And the charge is, well, you failed. In fact, you subverted it. So it's distinguishable in that way, it seems to me, both in terms of the time period that it endured for, but also the lifetime consequence. That's not to say that state capture and its consequences haven't devastated lives and families and so on. But we've had a commission of inquiry on state capture, and perhaps in time to come there'll be litigation in regard to the failure to implement what was recommended there. Well, who knows? One will see. But dealing with this now, we've got one of the central figures in our society, the first citizen, who is prepared to come forward and reveal all. And the litigants say, we don't want it. We don't want it. We don't want to delay. We don't want to wait for the commission of inquiry. We want to move forthwith, which is their entitlement. But in moving forthwith, there must be a finding. And the finding is of wrongful conduct. And it's not just ordinary wrongful conduct. You took money you shouldn't have, you signed something you shouldn't have, you gave a tender to somebody you shouldn't have. It's a finding that Mr. Mbeki breached his oath and betrayed the country, because it's a finding that he undermined TRC prosecutions. It's the finding in its effect, as I indicated, is a mark of Cain. Now,
but it's not a necessary finding. It's not a necessary finding in this context.
But why should any man subject himself to the risk? Because a third party decides that they will subject him to risk, that his name and a lifetime's worth of work can be taken away from him without any explanation and opportunity to give his side of the story. I know what the cases say, but I'm trying to talk it through here because there's a natural law element to all of this that even if one deals with those in the category of Mr. Koko or the Kutzes, where no person in a fundamentally just society should be subjected to any sort of slander or defamation by those who do it just because they can. So, and that's really the situation we're in now, but those cases have been decided, they've been dealt with. Here we're dealing with something that goes to the very root of who we are. All our legislation starts with recognizing the injustices of the past. The last 30 years, almost every piece of legislation starts with those crucial words. And here you have the head of state who says, I want to give the explanation, and those who want redress say, no, we don't want to hear from you.
They say, no, we don't want to hear from you in this court.
We don't want to hear
from you at the commission.
We don't want to hear from you now while we want money. We want damages. We'll hear from you later on. And, well, if there's two contradictory positions and whatnot, well, we'll worry about that then. Should any person be subjected to that? Isn't that a positivistic approach to the matter?
With respect, not, my Lord, because the better institution to get to the bottom of this is the Commission, which has its own investigative powers.
I'm with you on that, Mr. Chaskelson, and that's why I'm having trouble understanding why the damages and the declarative don't wait until after the Commission. Because if the Commission makes its finding, where everyone's been heard, they can't come and then say, well, I wasn't heard and I didn't give my version. Because it's there, it's going to be recorded. They're not going to file papers that are going to muddy the waters or anything, because everyone will know the state of play. But your clients have chosen a specific course of action which can result in contradictory outcomes. And it's the contradictory outcomes which make this a unique situation we find ourselves in. Because the order that's sought seeks to accommodate the possibility of contradictory outcomes with no harm to the applicants. And I don't think that's unreasonable on their part. Yes, the intervention applicants.
But your Lordship has to have faith that in the event that your Lordship's successor in deciding this, the main case in this matter, has to decide it before the Commission has run its course, and has to decide it for whatever reason without the benefit of Mr. Mbeki, an affidavit from Mr. Mbeki on the part of the government respondents, and an affidavit of Ms. Mabandla on the part of the government respondents. Then whoever sits in your Lordship's chair on that day will be astute to make whatever finding is necessary on the evidence, but to do so in a judgment which makes clear that, for whatever reason, we haven't had the benefit of Mr. Mbeki's version, we haven't had the benefit of Ms. Mabandla's version, we haven't had the benefit of Mr. Salebi's version, Mr. Jafta's version, a whole string of other people who are alleged to have acted in particular ways. But on the evidence before us, we find that there was interference or that there wasn't interference. And the question of who was responsible for what interference, if any, took place is not for us to decide. It's for the Commission of Inquiry to decide. And the court, by doing that, will be confining itself to the judicial function of determining a dispute between the parties to the dispute on the basis of the evidence that those parties choose to place before the court. Doing it in a manner that confines any collateral damage to non-parties. And that can accommodate the concerns of these intervening applicants. The intervening applicants' reputational rights should stand or fall by what the Commission of Inquiry finds. That's the place where their involvement, if any, is going to be investigated thoroughly and will be the subject of findings. There's no need for findings against these individuals in this case. And even if it were necessary to accept certain allegations made against these, certain unanswered allegations against these individuals for the purpose of this case, this court could, like the court in the Koko matter, simply make a finding that doesn't name them, and that makes clear that the finding was a finding made on the evidence before it, and unlike the Commission, it didn't have the benefit of, investigating proactively into it. And that would confine, well, would resolve the problem that the applicants are raising in this case. Indeed, my Lord, once your Lordship accepts that the Commission of Inquiry is the better institution to address this specific issue, then it's for the stay application court to decide whether these proceedings continue in parallel with the Commission. And the argument of the applicants in that regard is, if this was all happening 15 years ago, we'd be happy to wait for a Commission of Inquiry to finish and to make recommendations, and for those recommendations to be implemented through whatever process. But it's not happening 15 years ago. It's happening, 50 years after our loved ones were killed. We're not going to be around much longer. Some of us are not going to be around much longer. We can't wait. The court that considers the stay application next week will have to weigh all of those up, but it's for that court to make that call. And once your Lordship accepts that the better institution to investigate and determine these issues is the Commission, then with respect, this intervention application must fail. And it will be incumbent on the judge that, if the matter goes ahead in advance of the Commission, it will be incumbent on the judge deciding the matter to bear in mind that these are very, very serious allegations that have been made. There may be some people implicated who have not had an opportunity to get their affidavits before the court. And while the court must decide the list on the evidence before it, it must also do so in a manner that doesn't unnecessarily stain parties who haven't used it. But it's not a reason to let those parties intervene. So those, my Lord, are our submissions on the merits. There remains the question of costs, and our submission is the intervention application should be dismissed and that costs should follow that result. But the opposite doesn't follow, and it also highlights the inappropriateness of interventions in this sort of context, because when a litigant brings an allegation of unconstitutional action against an organ of state, the law protects that litigant from the chilling effect of a threatened costs order through the Biowatch principle. And Biowatch says that a litigant who asserts a constitutional violation against an organ of state is essentially, and who does so in good faith, is protected from an adverse costs order. So if they win, they get costs. If they lose, they don't get costs. What's happened in this situation is that we start with a basic list between us and organs of state, subject to Biowatch. Two individuals who used to be president and minister, in their personal capacity, want to intervene in that process. They want to intervene personally. They say, if you find in favour of us, we're entitled to our costs. That's fundamentally inimical to Biowatch. It's fundamentally inimical to Biowatch because one of the principles of Biowatch, which I think the SCA was first to enunciate, is that in interlocutory proceedings, ancillary to the primary constitutional dispute, the Biowatch principle applies. So if you oppose an interlocutory application in the context of a constitutional claim against government, you are immunized against costs even if you lose the interlocutory process. The SCA judgment that determined that is, if I can give your lordship the reference, is Phillips versus Reserve Bank. A 2013 volume 6 essay, I think it's 450, it may be 456, I can't read my reference, SCA. And if individuals who were formerly in positions of state authority can intervene in this sort of litigation in their individual capacity and claim costs, that's another reason not to let them intervene. At the very least, their intervention should be subject to the Biowatch principle. You can't convert an application brought by a bona fide litigant against the state into one in which they're now suddenly exposed to costs because you, as a former occupant of the state positions that are being implicated, sue to set the record straight.
In these proceedings, if I'm with Mr. Meinek, if I'm with you, I understand you say I'm dismissed with costs. If I'm with Mr. Meinek, is not an appropriate order costs in the cause, simply because one must wait for the ultimate outcome to know what the position is. If ultimately the state, assuming Mr. Mbeki and Mr. Mbandla filed an affidavit and it establishes a particular position and they say, well, yes, okay, we accept that that's the position, and they resolve the matter and they tender the costs, your client would then get the costs of all of these proceedings because they cost in the cause. Or is it not competent because those government parties aren't here to make that costs, and therefore any order for costs should then be reserved?
I think, my lord, your lordship just put your finger on it. I don't think one can make a costs in the cause argument in the absence of government respondents. But quite aside from that, my lord, the Biowatch argument is an argument of principle. And so, irrespective of what happens to the final case, if they are entitled to intervene, one, we shouldn't be mulcted in those costs, and two,
they would go to the state and they would say, well, you see, we've got leave to intervene, we ought to have been there, you must indemnify us for our costs. But that's between them and the state.
That's between them and the state. They can try and resolve that. I think that would be our submission. But our primary submission is that this intervention application should be dismissed with costs because it is a dramatic departure from the existing law, which just isn't justified. There are a range of other mechanisms available to these applicants.
Mr. Meinek says costs of two counsel, that both teams are ranged against each other with many more than that.
We set costs of three.
Costs of three.
We're happy on the basis of the Biowatch, of the applicability of the Biowatch principle, to agree that it should be costs of three. And if your lordship,
if I'm with you, then it's costs of three, and if I'm against you, then it's Biowatch.
Then it's Biowatch. But what your lordship might say, in order to accommodate my learned friend and his team, is that, but for Biowatch, your lordship would have awarded the costs of three counsel. So then, if they want to get into debates with whomever may or may not indemnify them, that is there. But we hope it never comes to that. Thanks, my lord. Those are our submissions.
Thank you, Mr. Justice. Mr. Meinek, reply, please.
Just observing on the cost issue that my clients are both retirees and no one is going to indemnify them, even if my lord were kind enough to say I would have given you cost of vehicles. But I'll come back to the cost issue. The first issue I want to address is the question of principle, and that is the main judgment as applied in Libya. So we submit that, firstly, our learned friends have never said, and none of the judgments they have referred to, including the judgments discussed in the judgment by divorce AJ, none of them say Win is wrong. That principle of Win, I'll call it the exception for the moment, that the exception in Win is wrong. But more importantly, Libya applied Win, and Libya is the constitutional court which is binding on all of us. Because after discussing Win, at paragraph 29, the court said, I do not think that the decision in Win can assist the applicants in any way, because this, like in the other cases which were dismissed, were about witnesses upset by credibility findings. So Win is good law, that exception remains good law. And we are in that context because it caters for the present case precisely, where the very course of action is premised on conduct by my clients. That conduct must be declared unconstitutional in the declarator. And that conduct, that declaration will then give rise to a damages award. And that damages award, my lord, the extent of that damages award will be affected by which period that the claim was affected by the unconstitutional interference. So it's completely different from the cases where witnesses come after the fact and are upset by findings, credibility findings made against them, and want to correct those. And this case is also completely differentiated from review cases, my lord. And my lord presiding, my lord made it very clear why the evidence of a witness in a review is so irrelevant at paragraph 38 of that divorce judgment. And this is this. Counsel for ABB referred the court to recent decision in Kutzer versus Office of the OCJ, handed down by Miller J. on 13 May 2025. The facts of this case were that the applicant sought leave to intervene in an application for self-review of a tender awarded by the Office of the Chief Justice. Pursuant to the award of the tender and signature of a contract between OCJ and TR, it emerged that the first to third applicants, former employees of the OCJ, had established the fourth applicant and had then submitted the tenders. And then quoting this court's reasoning at paragraph 41 says, again, the factual similarities between the matter in Kutzer and that of Koko are striking. They are both review applications, my lord. In Kutzer, the court held, to my mind, the main review proceedings will be decided based on the record of the proceedings which are under review. Because you look back to when the decision was made, not anything that's brought after the decision. This record sets out the conduct of the applicants while they were employees of the OCJ. The court here in the review will decide the relevance, if any, of the conduct of the applicants regarding whether the review is to be granted or not, and will consider the veracity and appropriateness of any adverse statements made about them in its consideration of the matter, in respect of the record. Now, if one just replaces the record in a review with what the court is going to decide this matter on, the court is going to decide this matter on based on the contents of this founding affidavit. That's different. It's not a record of review. It's the very allegations they make against my clients, which will be the basis for the finding that there was conduct by the administration at a period in time which interfered with prosecutorial independence, led to stoppage of TRC cases, and breaches the Constitution. That's the relief that they seek. And flowing from there, they want damages. Lord, they say, well, don't worry about them being named, because the court hearing the review application the main application will be astute not to name them. My Lord, one requires prescient vision to know that that will happen. But the evidence, the indications we have is that there is no guarantee of that, and Rodriguez is one example of that. My Lord, Rodriguez was an application for permanent stay in which similar allegations were made, and relying on an affidavit of Mr. Vusi Pikoli, that there was political interference by this president, by the former president and his administration. Was the court astute? Well, let's look at paragraph 14 of that judgment. It says this: the third period is the period from 2003 until 2017, the same period here. This is, in my view, the most crucial period because it relates to the period when the alleged political interference by the executive, the alleged amnesty granted by the state president, we know who that state president was and who was occupying that office, and the alleged agreement between government and other interested parties occurred. Agreement with the generals, my lord, not to prosecute them in exchange of not prosecuting the apartheid generals or ANC leaders. Now, paragraph 14 tells you who it is that's involved in this period, because you know the state, you know the president, you know his administration, and you know what they've alleged about these agreements. Then at paragraph 17, it makes the finding. According to the record, Advocate Vusi Pikoli, who was the National Director of Public Prosecutions during the second period, complained about the interference of the government when he wanted to prosecute apartheid-era perpetrators who had not applied for amnesty or were denied amnesty. It was not contested that from 2003 to 2017, investigations into the TRC cases were stopped as a result of an executive decision. This was indeed interference with the NPA. They want to argue this before the judge here in the main application, uncontested. Now, everybody reading paragraph 14 and paragraph 17, even the journalists in the room, know who these findings are against. So where is the astuteness that we are being promised? We're being sold pie in the sky, my lord. The fact is, this court cannot say what the court here in the main application will and will not make as findings based on the affidavits that have been filed. The real test that the application hinges on the allegations against the former president and Ms. Mabandla and their administration is that my learned friend can't say his client is willing to remove the allegations against...
Well, he says he couldn't take instructions from everybody. So,
actually, but I think, yes, we'll hear tomorrow, but
yes,
for the moment, they are relying on those allegations. They are not withdrawn. And so they are not withdrawn because they form the fulcrum of the application. And a judge hearing the application has to decide them. What is the answer to this by our learned friends? They say, well, those allegations are, firstly, the allegations against former President Mbeki and Minister Mabandla are not the core to the declaratory relief. They relate to the Commission of Inquiry. That's the first argument they made. You will find nowhere in this application where the founding affidavit says, this whole story we have told you has nothing to do with the declarators. It has only to do with the Commission of Inquiry. To the contrary, my lord, I took the court to the various passages and the conclusions in the founding affidavit linking directly those allegations by members of the executive at the highest level. Former President Mbeki was deputy president first, and he was then president. He occupied the highest levels of government, of the national executive. They said it is the conduct of those who impose their will on the NPA and the SAPS to stop or undermine the TRC cases that whose conduct gives rise to the declarator. My lord will read again from 001-217 until the conclusion that the court will find at 001-240, which says, in the circumstances I have set out sufficient ground to warrant the declaration sought in the notice of motion that the interference, and then they catalogue the violations, which they've already told the court. And my lord, when they say they impose their will on the NPA and the SAPS, they mean all of those people on the ground were implementing instructions from the top, the decision from the top. That's what it means. And it's clear, my lord, because this was also the argument that...
you say that their defense would be they were following orders.
Yeah, that's...
well, now you've got the person who purportedly gave the orders. And you say,
Yes.
well, we don't want to hear from him.
We don't want to hear from the
We just
person who
want to
gave the
know-
orders.
We just want to know that orders were followed.
Yes, right. We've already heard, I think, one deputy national commissioner is in this court saying he was following orders.
Yes,
It's
I'm
following
not sure
orders.
that's the right way to characterize it. I
Yes.
put it that way, but
Yes, but
yes.
that's what they will say. That's the scheme. But it's clear from the affidavit, my lord. And these are addressed. The second argument, which is that
But there's facts that are peculiarly within the knowledge of the first and second applicants for intervention,
Right.
which are not here.
we are not here.
And
then
that's
there's-
really the crux. Your case, the families say we don't need those allegations for purposes of this litigation for a just outcome. Go and tell the Commission of Inquiry. Your case is, this is crucial for proper determination of this aspect. We'll tell the Commission of Inquiry, but we also want the court to know, and there's reference to prior attempts to put your case before the court that were frustrated because you came late and various other things.
yes, we want, because this court is going to make a finding that there was interference during the period of my client's administration by him, and they make it clear that he opened the door to the interference. He was the architect. They say that, my lord, paragraph 001-66, I've already referred to this, opening the door to political interference. They've made the whole allegations there about him setting up the scheme for interference. And my learned friend disavowed that there is an allegation which says what followed from his decision, the former president's decision. But that's paragraph 129. It doesn't need much interpretation because it says so. It says, following Mbeki's speech, those wielding power and influence wasted little time in closing down the TRC cases. And then the chapters follow. So this is not from a book. It's not from a book or from a journalist. That's their allegations which they make. And they also say at paragraph 140, that the fact that the NPA was told to contact the president reflected that the question of investigating the TRC cases was now a purely political one, and a sensitive one at that. It appeared that only the head of state could make that decision, regardless of what the law and constitution said about investigative authority. That's paragraph 140. That's not from a book, that's what they say. And paragraph 183 says, here they are relying on the book, Bubenza. 183, according to an interview conducted by the author Ole Bubenza with Wagner in Pretoria on 8 May 2006, when Wagner was advised that the arrests were going to be effected, that's the Chikani arrests, he immediately intervened politically and put great pressure on the government to stop the proceedings. Wagner claimed that authorization to suspend the arrests came from President Mbeki in an extraordinary swift move. They placed reliance on that statement. It's their cause of action. And then 272, my lord. And here, my lord, is important, and we know the court will do this, is one doesn't read the chronology to make a finding. The chronology is a summary, just pointing out the highlights and the time period, but the substance of what is said is in the affidavit. 272. Writing in his 2015 affidavit in Kadiming 2, Piccoli observed the following. I have little doubt that my approach to the TRC cases contributed significantly to the decision to suspend me. They rely on that in this application. And then they say at 274, now with Piccoli and Ackerman out of the way, government was in a position to appoint compliant officials to lead the NPA and take charge of the TRC cases. Going forward, the TRC cases were now firmly frozen, and no amount of lobbying and agitating by families and their representatives would move the new leadership of the NPA to act. The president appoints the leadership of the NPA. After Piccoli was removed, he appointed the acting NDPP. So he appointed a compliant official to carry out the strategy. It's the president's decision, as they allege it. And then you will see paragraph 401 to 402. they say again 4.1, they say former President Mbeki denies involvement, but they say in paragraph 4.1, relying on the journalists, powerful Mbeki administration officials blocked the prosecution of apartheid cases. These are ministers that are responsible to him and they appointed by him. And then they say this denial at 4.05 is not consistent with the brazen suppression of TRC cases that occurred during his administration and which has been set out above. So he started off, put in a scheme in place. At a point in time, an NDPP comes into the picture who wants to prosecute, and he is suspended because of his approach to this TRC prosecutions. Now, what my little friend says, well, what the government or organs of state are telling the court is the president on the one hand says, it's not me, it's the NPA. The NPA on the other hand says, it's not me, we're instructed by the executive. There's finger pointing. So the court must decide. There is finger pointing, the court must decide because they want relief against government plus the NPA. So who must the relief be granted against? They are happy to have the NPA in court pointing fingers at my clients. But my client must be shut out and not contest their allegations, contest the finger pointing on which they rely. The interest, if that is not implicated by the interest of justice, nothing is. This is the height of what Section 34 is there to protect. Yes, in making the submission, my Lord, Ms. Mabandla is named. Her conduct is described. She's not tagging along. She's here to protect allegations which must result in a finding of unconstitutionality, of a breach of the Constitution. My Lords, and I said the interest of justice, and the court has remarked on this, that what they are asking is for the former president and Ms. Mabandla to stay out, have findings uncontested made against them that wipe out their whole life of commitment to fight against apartheid, and their contributions to setting up the TRC and making sure the TRC worked. They may have done wrong, but they're entitled to be heard. Criminals are heard in these courts before findings are made against them and they are sent to jail. Why can't the former president and Ms. Mabandla, when they fall within the win exception, and no one, not even the highest court in the land, has said the win exception is unlawful, it's not part of our law. It is part of our law and we fall within it. And the applicants can't pick and choose which allegations that they have chapter and verse put in their founding affidavit are the basis of their application in argument before another judge when they have set it all out here. Even on the question of costs, if they do that at the time of the main argument, a party against whom they now say we don't persist with allegations against you might say you must pay my costs. You've dragged my name all this way. I've come to court now. Not only are you saying I have put up the correct version, you're just simply saying we no longer rely on what you've said. But all along you were not prepared to remove those findings from your affidavits. So with respect,
are you suggesting that perhaps the appropriate order for costs is cost reserved?
Cost reserved, we would submit that that's the appropriate order.
If I'm with you. If I'm against you, then
we against us, we will pay their costs.
Then you've got to pay.
Not three costs, three counsel, I think 2 counsel is fair on both sides. I'm representing retirees, my lord. And these are retirees, they're individuals. My learned friend consistently argued to the court that they are not coming to court as in their representative capacities because they are not in office anymore. But when he argues by what he says, you must place us in the same position as the current administration. My lord, that's not what Bawat says. We are not organs of state. We are retirees. We're living on pension. And my Lord has dealt with the Commission of Inquiry. It is not an answer, because the court will have made binding findings, and all it makes are findings and recommendations that are not binding. We have been told we can be witnesses to the current government. Well, that's not the question. The question is, have we made out a case for intervention?
But factually, in any event, the current government has not yet put themselves back on record as opposing the matter. So,
No, they have blown hot
as
and
we
cold.
stand today,
We don't know what they'll do.
yes.
And we've made a point in 16.3 of our founding affidavit that our interests may not align in any event. And then, my learned friends, is an additional point is there could have been no lease before today had they not applied to reinstate. And when we came, there was no lease because they were not opposing. My Lord decides the case today, as matters stand today. As matters stand today, there is a lease. This, we are not in Wayne or in the other cases where there's been a settlement and so on, a judgment with no appeal. We are not there. It's very telling, my Lord, when the court says, but, well, if you're saying that the commission will get to the bottom of this, why don't you wait for the commission for these declarators? They don't want that. They want to pursue the current application, their election. But the point is simply this: there's no agency for the monetary award, because they say that monetary award is not for their pockets. It's for all the good things that they want to do. So why is there agency after so many years? Sadly, I share the court's observation. We all said that the state is the state of affairs is as it is. But the point of the matter is, there is no agency for the payment of money because of what they say they want the money for. Yes. The commission, they say, is for catharsis. But in the meantime, just make these findings against my clients in their absence. With respect, that is the height of injustice. I'll not spend a lot of time on the development of the common law, because our point is the exceptional circumstances are catered by Win, catered for in Win and Libya. It's only if the court says we don't even meet the Win test somehow, we can't imagine how, other than if our learned friends were prepared to say, you can forget everything said about, they can say to this court that they will say to the court here in the main application, strike a pen through everything we say about former President Mbeki and his administration and Ms. Mabandla. We want our relief without those. Then we can accept that court will not be necessary for that court to make findings in respect of my clients for the period in which they were.
Well, those allegations wouldn't be before it.
They wouldn't.
So it wouldn't be open to it to place reliance on them.
Quite.
But for so long as the allegations are there,
Yes.
what another court will do is what another court will do.
Yes.
We don't know what weight that court would place on particular allegations, or how it would frame its reasons for the order that it would ultimately make.
Quite.
I think it's perhaps
That's
wishful thinking to expect that it would be done in a particular way, given the context of a debate, the record of which wouldn't be before it.
quite. That's absolutely correct. And on the development of the common laws also, the case law is clear. We've all cited the same cases. I can only address myself to the pointers away from development that my learned friend said the court must bear in mind. The first one is there's no justiciable dispute. Well, that is to ignore what we say in our founding affidavit. There is a dispute. We deny the allegations of interference. We say those are disputed, and we want that dispute determined in an open court, because the determination of that dispute will impact the relief that is to be granted. Even the formulation of that relief as to which period is relevant, and the extent of the damages that will be awarded in respect to the extent of those damages, given the nature of the harm and the duration of that harm. So there is a justiciable dispute. my learned friend says there's no dignity issue. I referred, my lord, to paragraph 17 of Libya. This kind of case implicates dignity and Section 34, access to court. The COI, the Commission of Inquiry, is no answer. We've spoken about that. The being a witness to the government is no answer. Why should we, with a government that's blowing hot and cold, have to first come to court and say, we've tried to ask them to stop blowing hot and cold and take our evidence, and they've refused. It's abundantly clear before the court that that is the case. They say we must go and ask for declaration of falsity. Why should we wait for that when the allegations, the false allegations here, are going to be determined by this court? They are at the core of the cause of action.
Well, what would we do in circumstances where the court made an order based on those allegations, and then it turns out that they're false?
Nothing.
Does that vacate it? Would there be an application to vacate the judgment, or what would happen?
They would have to make it. They haven't said they'll do that.
I mean, it may create a conundrum.
A big conundrum, my lord. And how do we go and ask for declaration of falsity after this court has accepted the findings and made the order? Which we will come before this same court and say, court, you made the findings in our absence. We now want this court to declare those findings false.
Except those findings will have been made subsequently by the Commission of Inquiry, and there's authority for the proposition that you decide the case on what's before you,
Yes.
Namhlanje, today.
Yes.
So it's no answer to say, well, in 6 weeks' time, the position may change.
Yes. No. That's, and then they have the floodgates argument, but there's no one at the gate at present wanting to come in. So they can only say there's a universe of people out there that we don't know in other cases, but courts always fashion rules to take account of the current existing circumstances. When new circumstances arise...
Is it not that our entire society has been fashioned around a recognition of what happened?
Yes.
It's not even a matter of a rule. The entire society has been fashioned around a recognition of what transpired under apartheid.
Yes.
So to say, well, the court can't go a step further because of these particular circumstances. I understand the argument of Mr. Chaskelson.
Yes.
I'll have to think very carefully about it, but it must, I think, necessarily weigh heavily on my mind. I mean, context, as with everything, is everything.
Context is
particularly in something of this particular nature. It's very unique.
It's very unique.
It's not some commercial matter.
With respect.
Yes.
And our main submission is the court won't have to reach the development of the common law because the win principle actually allows us in. I've dealt with the question of costs. I've looked at Phillips' visit stuff very briefly because I asked my learned friends to call it up. I couldn't find a principle. We just wanted to look at what it says. So, paragraph 58 says, it is clear in my view that this principle does not only apply to orders on the merits in constitutional cases, but also to what may be described as ancillary points. That must be so follows inter alia from the fact that a litigant wishing to vindicate a constitutional right might well be discouraged from going to court by the fear that some technical or procedural slip on the part of his legal representatives might result in a court order with financially ruinous consequence for him or her. We're not there. All we are saying is we are retirees, my lord, and we're not organs of state to which Power Watch applies. We are just individuals, and in that there is nothing that would immunize the applicants. Ultimately, when the matter is argued, if my lord is with us to reserve costs, then the matter will be decided at that point. My lord, let me just check if I have missed anything. My Lord, I'm just reminded to emphasize that we did give the court the references in the government's founding affidavit for reinstating the opposition and stay,
Yes.
that they've said what they want to come and say. And none of that says they want to speak for us.
Yes.
In fact, they say, let's wait for the Commission of Inquiry. So that is not an answer to that problem. My Lord, other than for that, those are submissions, and we really thank the court for the indulgence that you've given us.
Yes. Thank you, Counsel, for your submissions and your heads of argument and for the debate. It's been spirited and very interesting. Judgment is reserved. I'll endeavour to let you have judgment before the weekend. It will be a written judgment. It will be sent to your respective attorneys and will be uploaded onto case sites.
As the court pleases.
The court will adjourn.
Before the weekend. And like this thing, I feel like I should be thought about. Exactly. I also feel like you should work on that. Because my specific with this, I really aspect that you think about.
You must send the report to your client.
You have been summoned. Send the She's worried about you. Usually I have that problem. You can, I'm trying to cut those but you lift it back. By the way, we can share just for clarity. If you say that he say that
Okay.
Thank you.